Elections will come to order. The clerk will call the roll.
Chair Kane,
Here.
Vice Chair Gonzalez, Beckley, Busey, Clardy, Fierro, Jatan, Schofield, Swanson.
The quorum is present. Good morning, members. I'm going to begin with some housekeeping items. Committee members can participate from this room or virtually. In order to make this a smooth process, I will call on members who are present first and then any members that are attending virtually. We will take up bills by non-committee members first, if the author is present, and then move to the bills of committee members. As a reminder, if there is anyone that wishes to testify on any of the bills we will be hearing today, you must register on the electronic witness information kiosk located outside the hearing room before you testify. Indicate which bills you wish to testify on. We will be limiting public testimony to 3 minutes. If there are no questions, we will start with our first bill. Yes. Will the clerk please show Representative Clardy present? The chair lays out House Bill 643 and recognizes Representative Shaheen to explain the bill. Yes. Let's back up. The chair lays out House Bill 643. And is it because it's wrong? Awesome. My script's wrong. It's not dyslexia. Backing up again. Let's avoid that one. The chair lays out House Bill 463 and recognizes Representative Shaheen to explain the bill.
Thank you, Chairman Kane, Vice Chair Gonzalez, members. House Bill 463 seeks to make an individual ineligible to serve as an election poll watcher if the individual has been convicted of a felony. Our elections, as you know, are sacred, and integrity in our election process is vital. However, today in Texas, a person can be a poll watcher even though they've been convicted of a felony, despite the fact there are a large number of jobs that exist today that are not available to people that have been convicted of felonies. So, for example, if you've been convicted of a felony, you cannot be a police officer, emergency medical response individual, you can't work at a bank, obviously you can't work in our schools, serve on a jury. And I certainly believe in the power of redemption. However, it's reasonable to withhold certain responsibilities from individuals who have made poor life decisions. And one of these jobs is a poll watcher. We must protect the integrity of our elections, and House Bill 463 helps do that by making people ineligible to serve as poll watchers if they have been convicted of a felony. With that, Mr. Chairman, I'm happy to take any questions and reserve the right to close.
Thank you, Representative Shaheen. Before we go to questions, will the clerk show that Representative Swanson is not present? Let the record show Representative Swanson present. Okay. Members, are there any questions for Representative Shaheen? Chair recognizes Representative Beckley.
Thank you, Chair. So I just have some questions for you. Has there been some inciting event that occurred while poll watching that a former felon created a problem?
There have been issues with poll watchers in Texas and in other states. There's been recent incidents in Alabama where you had people of Vietnamese.
Not interested in Alabama. I'm interested in Texas, and I want to know a specific problem that the person was a felon.
There's been a series of issues with poll watchers in the state and outside of the state. Whether they were felons or not, I don't know the answer to that.
Okay, but this bill is dealing with felons.
This bill is dealing with felons.
So I'm interested in what's pertaining to this bill.
Sure.
So that you don't know if there was a problem, so you can't even say the nature of the problem or if the person was a felon or not.
I can testify that there's been significant issues with poll watchers disrupting the election process in the state of Texas and outside.
But you don't know if they were felons or not.
Whether that poll watcher was a felon or not, I don't know the answer to that.
Okay. And how many former felons are there in Texas?
I have no idea. I can Google it for you and find out.
Okay, well, you're laying out the bill, so, you know. So what is the racial makeup of the former felons in Texas?
I don't know the answer to that, but I can find out for you.
So you don't know a lot, and you want to put this bill in. Under Texas law, former felons can vote if their sentence is complete. Is that correct?
That's my understanding, yeah.
Okay. And so why are you not specifying, like, I can understand we were talking about elections frauds, felons that committed elections frauds, eliminating them from being poll watchers. Would you be up to an amendment that we limit that to felons that were convicted of crimes that deal with elections?
No, I'm trying to be consistent with other jobs that don't allow felons to participate in those career types. So again,
Well, those are career types.
police
This is
off-
poll watching, and it's
Excuse
like those are careers. Poll watching isn't really a career.
poll watching is analogous with those other job descriptions because they're positions of trust. A poll watcher is a position of trust. So we don't allow police officers to be felons. We don't allow people that are in banks in our schools to be felons. So it's logical to me that a poll watcher shouldn't have a felony on their record as well.
Well, I think that felons can, once they redeem, once they've served their sentence, that they need to be integrated into society. And this
I
is
believe
making
in
it more
redemption representatives just like you do. But at the end of the day, there's certain jobs that it makes sense not to open.
Well, it doesn't make sense because you haven't brought one incident to this bill to say that it makes sense to that you even. This is just hypothetical.
No, it's not happening.
You don't have the data.
I've told you a number of instances
That not one was a
where
felon.
poll watchers disrupted.
I understand
the
that, but
election
that's not going to
process.
solve what this bill's trying to do because you don't even know if they're felons or not.
Again, I can find out. I don't know how relevant that is. At the
It's
end of the
relevant
day,
because you're eliminating felons from being poll
That's
watchers
exactly
for
what
this
we're doing.
bill, so it's relevant to this bill.
Yeah, I mean, at the end of the day, it's very much a binary decision that each representative will have to make on this committee. Do you want people with a felony background to be a poll watcher or not? And what I'm asking you is to take in consideration the fact that there are other job descriptions that we don't allow to have a history of committing a felony.
Well, felons have
like
a hard time
police
getting jobs
officers.
anyways,
I
so now you're
understand that.
eliminating this as well, so you're
Well,
making
this
it
really
even
isn't a-
harder to
Poll watcher,
integrate.
people aren't poll watchers for income.
You're right,
Neither is
but
not.
maybe a felon is because they have no other options and they're trying to get off the Texas.
I doubt it. But at the end of the day, Representative, it's a binary decision whether you think a felon should be a poll watcher or not. Our society has made the decisions that felons shouldn't be police officers, they shouldn't work in banks, they shouldn't work in our schools, because those are positions of trust. And I would just tell you that a poll watcher is a position of trust. And for me, it doesn't make sense for that person to be convicted of a felony. Maybe we respectfully disagree on that.
Well, you have no basis for your opinion. That's the problem. You haven't presented one incident that would give a basis for that opinion other than that's just your opinion.
Well, it's more an opinion. I mean, our society has made conscious decisions on specific jobs that a felon shouldn't have. And my contention is a poll watcher is one of those.
I disagree. Thank you.
Chairman?
Any other members have questions for Representative Shaheen? The chair recognizes Representative Fierro.
Thank you, Chair. Representative Sheen?
Yeah.
Can you give us, and maybe I missed it in the exchange a moment ago, but can you give me some examples of the disruption in the poll places, whether they're
Sure.
in Texas, whether they're felons or not felons?
Whether they're felons or not, I don't know. But I mean, I've witnessed personally where poll watchers have been having to escorted out when I've been poll reading those types of things. Some poll watchers. I'm sorry, what?
And I'm sorry. I'm trying to get it clear in my mind because
Sure.
when I've been in a poll, whether campaigning, whether as a candidate or not as a candidate, it's really the rules are there. I mean, and both sides are following them, and so I haven't been privy to the disruption in a poll place.
Yeah, I have.
And that's why I'm asking for some
Yeah.
examples.
I mean, I was interrupted earlier, but I mean, there was an example of Vietnamese individuals that were targeted by poll watchers. There was individuals who hold certain stances that were being disruptive. So there's significant examples inside the state of Texas and outside the state of Texas.
Okay, I'm sorry. I don't mean. I just don't understand the disruption part. But
They've physically had to have been escorted out of the polling location
Or-
because of their behavior.
But examples of the behavior. And again, I'm not trying to. I just want to make.
They start speaking out loud to individuals. They start talking about their certain beliefs and certain topics, those types of things, where they're supposed to be silent and watching the process.
Right, right, and that's always been my experience.
Yeah.
Okay, thank you.
Yeah.
The chair recognizes Representative Busey.
Thank you, Mr. Chairman. Just one quick question, Representative, and I think you hit on it. I'm just want clarification as I'm evaluating this bill. Felons are not, under this bill, felons are not allowed. Is that including felons that are off paper? So beyond serving their time, they're off paper, they're back. They still wouldn't be allowed under this bill?
Yeah, once you've been convicted of a felon, even if your voting rights are restored, you could not be a poll watcher.
Okay.
It's similar. Again, I'm just trying to make it analogous
Sure.
with the other jobs.
No, I hear you. All right, that was my only question. Thank you.
Thank you. Are there any further questions, Ms. Fitty? The chair recognizes Vice Chair Gonzalez.
So this is actually kind of touching on what Representative Fierro was asking as far as disruption in the polling places. Can you describe an instance where there was a disruption and it was specifically related to the person being a felon somehow?
Again, like I've answered before, the examples that I have are disruptions. They were in the press, or I've witnessed them myself, or individuals have told me about them. I didn't then go and look to see whether they were felons or not. Again, I'm trying to make this consistent with other jobs that don't allow felons, and so I hold a poll watcher at the same level of trust as some of those other positions that I talked about, like working in our schools, police officers, those types of things.
So if this bill were to pass, which registered voters would not be allowed to be poll watchers?
The ones that are felons.
Okay.
The chair recognizes Representative Clardy.
Thank you, Mr. Chairman, and thank you, Representative Shaheen, for bringing this bill.
Thank you.
And I understand what you're trying to do, and appreciate the research and time you've put into this, and your preparation for today's hearing. But I was thinking, as I understand the law in Texas, once a person's been convicted of a felony crime, it's fully discharged, I think is the phrase, their responsibilities under the law. It does not drop off their record, but at that point they are re-enfranchised and they again have the right to vote. Just asking as an idea, would you consider an amendment that would allow that person, if you're a convicted felon still in the process of discharging your obligations to society, having been convicted of a felony, whether it be on probation or parole or other stipulations or conditions of the court, those people would be ineligible to serve as a poll watcher. But once you have completed your debt to society, then at that juncture, you're fully re-enfranchised, including the opportunity to serve as a poll watcher.
My attempt has been to try to make it consistent with the other types of jobs, and again, whether it's a police officer working in banks, EMT responses. Once you've committed that felony, you're prevented from holding those positions. So I'm trying to make a poll watcher consistent with that. That's my logic.
Yeah, and I appreciate the thought process in this, and I would certainly understand that if we're dealing with crimes of moral turpitude, and there may be some other restrictions. But for those people who have been convicted of a crime that doesn't rise to that level, it's not an issue of trust. It's error in judgment, of a bad act, a bad day. Lord knows we've all had them. That once they've, again, gone through the time, paid their fines, spent their days in jail or prison, once that's completed, I think the goal has always been for, through rehabilitation, have people return to a peaceful society and have that opportunity to once again be productive and successful. So again, I think there should be some limitations as who should be able and be eligible to be a poll watcher. I would just ask you to consider possibly, let's tighten this up, exclude certain crimes, certain convictions, and also until it is fully done and you've fully completed it, you're ineligible. So I don't disagree with where you're going with this. But I also think it is important in society that we give people, as you said yourself, you believe in redemption and an opportunity for people to grow and learn, and just hate to take something away from somebody that's so dear and sacred as the right to vote. Because mistakes were made. Like I said, we all make them, I'm not sure about you. I know I've made a few.
I've never been caught.
Just as so, just a thought to consider in the committee. But
I'll come by and visit you, and
Very
we can
good.
talk about how's that.
Thank you for bringing the bill.
Thank you, sir.
The,
So
the
are
chair
you-
recognizes Representative Beckley.
So who's going to verify whether they're a felon or not? Are we going to have to do background checks on all our poll
No,
watchers
so
now?
the process is they have to go in and sign an affidavit right now that says they don't have any equipment to take pictures or record or those types of things. So this would be added to that affidavit.
So you're adding a question to it, and then
Adding a what?
you're adding another question to that.
To the affidavit, that's
Okay.
correct. Yeah.
And so there's going to be no verification process for this.
No, it's like signing any other affidavit, right? If there's a reason to suspect that somebody has been untruthful in an affidavit.
So you think
affidavit
that
to pursue
there
it.
can't be a poll watcher, but they can? Do you think that everybody's going to tell the truth on this?
It's an affidavit. There's penalties for falsifying an affidavit.
Okay, so you think that's going to stop them?
What's that?
Because you think that they're so bad they can't be a poll watcher. You think that's going to stop them? Well, you think that they're so bad, a human being, that they can't be a poll watcher because they were a felon, but you think that just signing this affidavit is going to be good enough?
Yes, I do believe that. That's 100% correct.
All right.
It's an affidavit.
That's illogical, but okay.
The chair recognizes Representative Swanson.
Thank you, Chair. And Representative Shaheen, thank you for coming in. And I just, as somebody who has held many elections over the years and values the elections and the whole election process, I want to thank you for recognizing poll watching as a position of trust. And I'm surprised this is not already in the law, but thank you for recognizing that as such a very important position.
Thank you, Representative. I was surprised as well.
Members, are there any further questions for Representative Shaheen? If there are no further questions, we will proceed to testimony. The chair calls Alan Vera, representing Harris County Republican Party Ballot Security Committee, who is registered for the bill. Is that correct?
Correct. Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, speaking in support of HB 463. I have personally been training poll watchers in Texas under TEC since 2010. We take the training and vetting of poll watchers very seriously. The county party will not appoint a poll watcher and will not recommend a poll watcher to a candidate who has not successfully completed all the training and been thoroughly vetted. That's because we understand that poll watchers have a very serious responsibility, though unpaid in most cases. They can have a highly beneficial or detrimental impact on the conduct of the election at that location. So they have to be highly qualified and above reproach. This bill acknowledges that the importance and potential impact on election requires good poll watchers. This bill simply moves the bar a little higher with regard to the requirements and qualifications of a watcher. The Texas Election Code already prohibits election service by a person with prior election-related convictions, whether or not they've already satisfied their punishment. So that's not new, that's in the code. This bill simply extends similar criteria to the important position of poll watcher. This bill simply says, Texans, we need to do better. We recommend passage of this bill to the full House. Thank you.
Members, are there any questions for this witness? Okay. If not, the chair recognizes Alan Vera to close. Mr. Vera? To close? Or no, Representative Shaheen. No, we have more witnesses. Sorry. Who's next? Yeah, blame the speakers. Or his coffee. Okay. Is Marcia Strickler here? Strickler? Okay. The chair calls Marcia Strickler, representing, and shows Marcia Strickler is against the bill.
Yes, sir.
Hi, Ms. Strickler. Could you please state your name, whom you represent, and your position on the bill, please?
Yes, sir. My name is Marcia Strickler. I represent myself. I am also a GOP Republican delegate, and I am a poll watcher. I was a poll watcher in my county, Williamson County, twice last year. Once while my county reopened Central Count after the November general election due to a glitch in our 10X software that prevented the DS200 from reading the precinct level data, and again during a Proposition 1 manual recount for 5 precincts. Both times, I felt like I was exercising my duty as a responsible, concerned citizen to oversee the election recount process and to verify that our federal and state election codes are being followed. I take poll watching responsibilities very serious and feel that if a person is eligible to vote, they should be eligible to poll watch.
Okay.
We have good election code laws in our state. I think if this commission and our Secretary of State were to enforce the laws that we have, I think that this particular bill would already be enforced, sir.
Members, are there any questions for this witness? Okay. Thank you, Ms. Strickler.
Thank you.
The chair calls Ed Johnson, who is registered for the bill. You may begin, Mr. Johnson, if you please state your name, with whom you represent, and your position on the bill.
Yes, Ed Johnson. I represent myself. I have quite a history in elections. I spent 20 years in Harris. For the bill. Sorry about that. Spent 20 years running elections in Harris County. I was the director of voter registration for 10 years, and then I was director of the county clerk's office for 8, 9 years, something like that. For this particular issue, I have seen a lot of votes suppressed because we received in the county clerk's office numerous phone calls saying, I'm not going to go to that polling location to vote because they knew the people working in there had been convicted of felony offenses, serious felony offenses, murder, sexual crimes, forgeries, things like that. And we would get phone calls from voters saying, how can that person be in this polling location? And they were intimidated and afraid to go vote with these people there when they knew from their neighborhood that these were bad guys. So it's a voter suppression. We actually looked at, when we would receive complaints in the county clerk's office, we would look at the affidavits coming back because they had to submit an affidavit when you're a poll watcher. And we found that numerous of the poll watchers that were being complained about did have felony convictions on their records. So there is no crime right now for that. I don't think any of those records were kept. We were just doing it for research. So it was in a voter intimidation factor thing. I heard 3 sessions ago there were numerous people from the Valley that came up here to do testimony, and every one of them said that when they would go to the polling locations, they felt intimidated because there was a poll watcher there. It was usually someone from their boss's office or from the union they belonged to down there that were kind of like the union thugs that were there harassing them to vote. So this is a very serious issue. It is a voter suppression issue.
Members, are there any questions for Mr. Johnson? The chair recognizes Vice Chair Gonzalez.
Thank you. So how did voters know the criminal background of these poll watchers?
Because they live in their neighborhood.
So they
knew them.
They took the time to look up each single person that was poll watching to find out what their criminal background
No, they looked at the one that they were going to their poll, and they knew that the guy that lived down the street had been convicted of murder.
So how do they know who was going to be there poll watching? I mean, is that it just...
When they walked in the poll, they see this guy, and they would leave because they didn't want to be in the same polling location as him.
So they just happen to know the criminal background of every single person that was there poll watching?
They don't know the criminal background of every single person, but they knew the criminal background of the guy that was sitting there watching how they were voting.
Thank you.
The chair recognizes Representative Beckley.
So, did these poll watchers cause any disruptions? Were they doing anything that was not part of their
Yeah,
job?
voter suppression. Voters would not come in to go vote.
Okay.
Members, any other questions for this witness? Thank you, Mr. Johnson.
Thank you.
The chair calls Laura Presley, who is registered against this bill. Good morning, Ms. Presley.
Hello,
Could you please,
Chair.
state your name, whom you represent, and your position for the record.
Thank you, Chair Kane. Yeah, I'm Dr. Laura Presley, and I am opposed to this bill. My history is I formed True Texas Elections, which is a LLC that trains poll watchers all over the state of Texas. I've trained probably personally 300 watchers all over the state. And we have formed what's called the Joshua Council. And I think each one of you have received one of our letters from our Joshua Council Texas Election Watcher Coalition. One of the things that concern me, and in our coalition, I've trained probably over 300 watchers in 35 counties. And we, in the November election in 2020, we served over 9 million voters at the central counting stations with watchers. And they're cross-partisan, and it's probably the first time in the state of Texas and probably the first time in the country that 9 million voters were covered at the central counting stations, not just at the polls. So one of the concerns I have about this bill is that, and I don't know if there was an amendment that was put up, but the bill that's posted says misdemeanors. And that is a real concern that I have. It doesn't say Class A, Class B, Class C misdemeanor. My belief is today in this moment, a watcher cannot be appointed if someone is currently in a felony and has not been discharged from that felony. They have not served their time. The election code does not prevents a voter who has that history and has not had that discharge. They're not qualified to vote. If they're not qualified to vote, they're not qualified to be a watcher. You have to be a legal voter, an eligible voter to be a watcher. So I'm not so, Representative Busey, you've said that, and Representative Clardy, you've concerns about this felony issue. Well, it's already there. It's already in the code. You can't be a watcher if you're not an eligible voter. And that takes care of the felony piece. So then I have to ask really, what's kind of going on here? The misdemeanor is a very big concern. I mean, there's, a speeding ticket's a misdemeanor, Class C. We're talking in this bill about election offenses. My belief is that if you're a voter, you should have the ability to monitor if your vote is counted at the central counting station. Stalin said it doesn't matter who votes, it matters who counts. If you're an eligible voter, you should be eligible to watch your vote and make sure it's counted legally. We've had issues all across the state of Texas with watchers being obstructed. There's a case right now in the Texas Supreme Court. It's Bickham and others versus Dallas County, where watchers have been obstructed. Watchers have been accused of disruption, and that those are false claims that have happened. There are multiple counties where watchers in the central county station are not welcome. They're not welcome in Dallas, Bexar County, Williamson County. I was a watcher in Williamson County. I was not permitted into the central counting station. We had to contact the constable, Stoffel, Kevin Stoffel, and he had to come into the elections office and talk to the administrators and the election officials to get the watchers into central count. Watchers in some counties are not welcome. I see this as a mechanism to escort them out. I mean, Representative Shaheen, somehow equated escorted out with misdemeanor and felony. That doesn't make any sense to me. If watchers are going to be escorted out and prosecuted for a Class C misdemeanor for trespassing, that person cannot be a watcher again, and that is my concern. And that is unreasonable because we have counties that do not want the watchers there. This is just another means for them to prevent them from being in there.
Mrs. Presley.
Okay.
You're at a 3-minute mark. However, we're not done yet if anyone might want some questions. But I do have a question for you real quick.
Yes, sir.
For the record, who are you here representing?
I'm representing the Joshua Council, Texas Election Watcher Coalition,
Okay.
and myself.
Thank you. Members, are there any questions for this witness? Seeing none, thank you, Ms. Presley.
Thank y'all.
The chair calls Bradley Hodges. Bradley Hodges. All right. The chair calls James Slattery. Did I say your name right, Mr. Slattery? Mr. Slattery, I show you are registered against this bill. Is that correct? Okay. I'm going to ask you 3 questions. If you could please state your name, whom you represent, and your position on the bill for the record, please.
Great. I also have a copy of the testimony.
Excellent.
I'm James Slattery. I represent the Texas Civil Rights Project, and I'm testifying against the bill. First, the bill is unreasonably wide in scope. It applies to everyone with a felony conviction, regardless of the seriousness or nature of their offense, including whether the offense had anything to do with elections. It also applies regardless of how many years you have been a law-abiding citizen since completing your sentence. Not even a pardon seems to restore your right to be a poll watcher. The bill is even more restrictive than felony disenfranchisement laws, which restore the right to vote once you have completed any term of incarceration, parole, supervision, or probation. The absurd scope of this bill can be seen in the simple fact that many thousands of Texans would be prohibited from observing elections that they themselves are voting in. We also cannot ignore the fundamentally racist nature of proposed laws like these that strip people of their civil rights based on a felony conviction. Felony disenfranchisement laws arose during the Jim Crow era, which worked in tandem with criminal laws applied selectively against people of color to ensure that they were not able to vote. Because of systemic racism in the criminal justice system, those who are incarcerated in Texas continue to be disproportionately people of color. While black Texans, for instance, make up only 12% of the state's total population, they constitute a third of our state's incarcerated population. As a result, one of the ultimate effects of this law is to take away yet another civil right of many black Texans and other people of color, and discouraging others from participating in the political process at all. We therefore urge the committee not to adopt HB 463.
Thank you. Members, do you have any questions for this witness? All right. Thank you, Mr. Slater. All right. The chair calls Lisa Nilsson to testify on this bill. It shows Ms. Nilsson is going to be testifying against the bill. Ms. Nilsson, if you could answer 3 questions for us. I'm going to ask you, please state your name, whom you represent, and your position on this bill for the record, please.
Yes, my name is Lisa Nilsson. I represent myself in this, and I am opposed to this bill, and I'm primarily opposed to the misdemeanor section on this for some of the same reasons you've heard already stated. But before I explain that, I do want to let you all know that I myself have been a poll watcher. I was a poll watcher in Bexar County at Central Count on November 3rd. And so I do have some experience and knowledge in this. And my concern is that over time, that it can become let me say I'm opposed because, first of all, I believe that anyone who's legally allowed to vote should have the legal right to be sure that their vote is legally and lawfully counted and that the election laws are properly being followed. I believe that this misdemeanor section in here, again, because of the broadness of its scope, that it could be used to politically, by politically hostile or adversarial county officials, the election supervisor, even sheriffs, to harass and eliminate watchers that they believe are trying to hold them accountable to follow the election law. And it may not happen the first time, but over time, once watchers get trained and they realize what's going on, they sign up to be watchers again and again and again, and faces become familiar. People know who each other are, and we know that there are certain things that we're watching for in the process. And quite truthfully, I found myself in and around the time of the election being very careful in Bexar County, that I didn't want to be pulled over and harassed or followed home from the polling site or anything like that because of some concern about the potential for harassment. I think that elections have become, sadly, something a lot of people are losing confidence in, and there are a lot of people who are worried that if laws aren't being followed properly, they want to be involved. And I just think that this discriminates, that if you have the legal right to vote, you should have the legal right to make sure your vote is being properly counted. And so I'm highly opposed to this bill. Any questions? Thank you.
Thank you, Chairman Kane and members. Our election integrity is vitally important. And again, I think it's very reasonable to make poll watchers consistent with other positions of trust. This is clearly a position of trust. This has nothing to do with race. Those comments about racism were absurd. I'm an individual that has experienced racism firsthand. I would not promote legislation that was racist. I reject the comments by the Texas Civil Rights Organization. They don't apply to this bill. This bill requires that an individual who serves as a poll watcher merely sign an affidavit that they are not a felon. It's a very simple process and will do so much for our election process. With that, Mr. Chairman, I close.
If there is no objection, the bill will be left pending. Thank you. The chair lays out House Bill 478 and recognizes Vice Chair Gonzalez to explain the bill.
Thank you. Excuse me. Thank you, Chairman. Members, for giving me the opportunity to lay out House Bill 478. The Texas Election Code allows an election officer to deliver a ballot to a registered voter at a polling place, entrance, or curb if they are physically unable to enter the polling place due to a disability or health concern. Voters have expressed difficulties about accessing their ballot at the curbside due to unclear instructions or inconsistencies. HB 478 seeks to address the procedures an election officer follows by requiring a parking space at each polling location to be designated and clearly marked for voters who are unable to physically enter the polling place. The parking space designated under this bill would not be one designated specifically for persons with disabilities, meaning it doesn't have to be a space that's already designated as a handicap spot, for example, but it's to ensure that disabled folks can still enter the polling place if they choose to. Or if, say, the polling place is at a library, we're not restricting disabled folks from access. When a voter requests curbside voting, election officers confirm the voter's registration status and identification, deliver the ballot to the voter, and either the election officer or a person accompanying the voter will place the marked ballot in the ballot box. I know there's some folks here to testify as to the bill in support of, and with that, Chairman, I reserve my right to close.
Members, are there any questions for Vice Chair Gonzalez? The chair recognizes Representative Clardy.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this bill. The question is pretty simple. It says it may not be one designated specifically for persons with disabilities or a marked handicapped parking place. Why would you exclude that? I would think those would be the parking places most accessible, easy to attend to. Is there a reason we exclude that?
Meaning that so it doesn't have to already be a spot that's already designated as a handicap spot, and it doesn't have to be necessarily a parking spot. It could be on the curb. It could be somewhere else. So you can create a whole new area where you want to designate for persons with disabilities.
Yeah, but I just don't know why we'd want to exclude those particular places. If that's the best place to have it, why not have it in a handicap place?
And I believe that you can if you choose to, but if that's
Okay, well,
I think that's
it
what
just reads the parking space may not be one designated specifically for persons with disabilities. So it's excluded from using that at all. And if there's a practical reason or it's a violation of the ADA, I don't know if there was a reason not to do that. But good.
We'll look into that.
We'll look. Thank you.
The chair recognizes Representative Fierro.
Vice Chair, thank you for bringing this bill to our attention. My concern with using a designated handicap parking is that someone that comes that needs that parking space, and we're using it for, and I'm for this, but we're using it now for voting. I like the idea of finding an alternative area, maybe a curbside or some of your suggestions. So I can see why we're not designating a handicap, already designated handicap parking space. Thank you.
Members, are there any other questions for Vice Chair Gonzalez? Hearing none, we'll proceed to testimony. The chair calls Glenn Maxey with the Texas Democratic Party, registered for the bill.
Good morning.
Mr.
Glenn Maxey, with the Texas Democratic Party, representing the Texas Democratic Party here in support of House Bill 473. Right? 473?
478.
478.
So you're testifying for 478?
Yes, sir.
Thank you. Proceed.
It's great to be back with all of y'all. We'll see a lot of each other this session, and I'm glad to see my good friend Mike Schofield back, and nice to see a new member on the Elections Committee, and Mr. Clardy. I haven't had the opportunity to bother you a lot on election stuff, so here we are. On behalf of the Democratic Party, we see in our hotlines one of the biggest issues for people who are disabled or elderly who are trying to vote, who are mobility impaired. Curbside voting is a true godsend. However, the process of putting that into effect effectively in polling places around the state causes a lot of challenges. So this bill solves a real problem of saying that there needs to be designated parking for that. And I, as somebody who has received a ticket for parking in a handicapped place for only about 15 seconds, I think the issue here about the designated handicapped parking space is that if you use it and you don't have properly marked vehicle, you will be in violation of the handicap parking lot thing, and you can get a very severe ticket for doing so. So having it for people who need this for voting but haven't gone through the process of getting a handicap sticker is why they would have that differentiation here. So we are strongly in support of this bill.
Thank you, Mr. Maxey. Members, any questions for Mr. Maxey? Chair recognizes Representative Beckley.
So can you answer the question on that Mr. Clardy had as to why it wasn't necessarily a handicapped position spot? Do you have the answer to that?
Well, I think that's it. And, you know,
But Art Vieira said.
I mean, a person with a disability parking sticker could use the disability parking space if it was set aside for curbside voting, but the person without a permit on their car using that space could get a ticket.
Any other questions, members? Thank you, Mr. Maxey. All right. The chair calls Kate Garrison, president of the Collin County Democrats with Disability, and she's here to testify for the bill. Good morning, ma'am. If you could, again, please state your name, who you represent, and your position on the bill for the record, please.
Thank you, Mr. Chairman and members. Can you hear me? I'm going to take this.
There you go. You can certainly take it off. Feel free. It's your choice.
Thank you, Mr. Chairman and members of the committee. My name is Kate Garrison, and I am representing Collin County Democrats with Disabilities and myself in support of House Bill 478. This bill requires a parking spot to be designated at polling locations for the purpose of curbside voting. The bill requires that the parking spot be clearly marked, and the parking spot should not be one already designated specifically for persons with disabilities. This is an important point because the parking spots designated for persons with disabilities are very limited. 18% of our population are people with disabilities, and only 4% of the spots available are set aside for people with disabilities, and specifically for our needs. When curbside voting is set up in an accessible parking space, it eliminates that spot for those who want to vote in person or use the facility for a non-voting reason, such as use the library, go to use the recreation center, or go into a school. So it's important that we protect the integrity of that space. I know firsthand the frustration that can turn to anger very quickly. When I pull into I drive, and so I drive into a parking lot, and I want to use the facility for something other than curbside voting. And I can't because they set it up in the only van accessible space. And because I have a fixed wheelchair, I have a ramp that deploys on the passenger side. So I have to have that extra wide aisle. And if I don't have it, well, I'm out of luck. So that's the dilemma, and I see it every day. And so historically, I know in Collin County that is always where the judges set up curbside voting. And it makes sense because it's close to the door. And by law, designated spaces for people with disabilities have to be the closest to the door. So I get it. But there are also, in many cases, other places that you can actually a spot where you could have curbside voting. In Collin, we have several new places, and it was 150 steps to any kind of parking. And so we thought outside the box, and we said, okay, well, let's just set it up right outside the door. Well, that's in the emergency lane, but we're not parking. So people are just waiting, and they're being serviced, and then they drive off. So we've solved that problem. So you can think outside the box, and you can put it in various different places. And I know smaller counties will have a difficult time. This bill is also flexible. You can have more than one spot. So if you have, for example, an election, and you know the voter turnout is going to be higher, then you can send additional signage or set up a different space. So it's flexible. The model that is described in this bill is flexible, and it has been in effect in Collin County since 2016. We know that it works. So does the Elections Assistance Administration, U.S. Elections Assistance Administration, because they gave it a Best Practice Award. So we think that we've got a pretty good deal, and this bill is exactly what we know works. Thank you, Mr. Chairman and committee members. I'm available now to answer any questions you may have.
Thank you, Mrs. Garrison. Members, do you have any questions for this witness? Come on. The chair recognizes Ms. Beckley.
So my district's in Denton County, so it's just next door to Collin County. So I'm imagining that you have similar polling locations, that it's a variety because you've got both rural and suburban. So that this bill will help with both of those kinds of polling locations.
Yes.
Thank you.
The chair recognizes Representative Clardy.
Thank you, Mr. Chairman. Ms. Garrison, I just want to thank you for answering my question. So it makes a lot more sense to me now.
I'm sorry. I was having trouble hearing you all. And so I had a feeling that I might have been redundant.
No, it's perfectly on point. I think I was operating under the misapprehension that there would be I think there would be considerable overlap between people who need curbside voting because of some inability to access the physical location and people who properly can use handicap or ADA parking. But I also can see the dilemma you pointed out with the van accessibility. So we certainly don't do anything to impair that. So thank you for your testimony.
Thank you.
The chair recognizes Vice Chair Gonzalez.
Thank you. I just want to say thank you for coming out and testifying today and working with my office closely on this bill. And I think that you clarified some of the questions that some of the other members have. But I just wanted to thank you for taking the time to travel here to testify on this bill.
Thank you, Representative Gonzalez.
Okay, excellent. The chair recognizes Representative Schofield.
Ms. Garrison, thank you for coming today. And I always look for unintended consequences. So whenever we do something that is good and we just sort of, oh, that looks good, we go on to the next thing, I want to make sure we haven't screwed something up. And so as somebody who, of necessity, when you go into a public place, you're always having to be on the lookout to make sure there's access and that where they've put things is good. Do we run any, I'm thinking of smaller locations that only have a certain number of places. Do we run any risk of, if we don't use the handicap space for the voting, not having a good usable space? And I'm thinking of the polling place down the street from my house. They set up the handicap, they have 2 handicap spaces. They set them up directly across from their ADA accessible ramp onto basically the sidewalk that leads to the building. Do you, having gone to a lot of buildings in your time, do you foresee any problem with, if we say, okay, we're Xing out the handicap spots, there being locations that might not have another suitable place to put the disability able voting? And again, you've done this for a while in terms of voting.
I guess I'm always thinking outside the box. I do exactly what you say. I'm always looking and noting. And I have not come across any, frankly. Thank you.
Very good. Thank you.
Thank you, Ms. Garrison, for your insight on this issue. Members, any other questions for this witness? Thank you, ma'am.
For having me.
You got them. We'll ask you more questions than anybody else so far. So, good insight.
Good.
Members? No one else? Okay, so the chair calls Chris Davis, a well-known election administrator from these parts, testify for the bill. Mr. Davis, you know the 3 things we need to hear for the record. Your name, whom
Yes,
you
sir.
represent, and your position.
Good morning, Chairman. Good morning, members. Chris Davis, on behalf of the Texas Association of Election Administrators, testifying for House Bill 478. And I'll take this off. Excuse me. Was I clear? Forgive me, Mr. Chairman. We're for this bill. I may be slow, not had my coffee this morning. That last line of the added language in the paragraph of parking space may not be one designated specifically for persons with disabilities. Madam Vice Chair, is that permissive or prohibitive? I'm still not sure, given the prior testimony to me, how to read that part of the paragraph in the language. And there is a slight fiscal impact for counties, given with signs, without signs or markings. There's some counties that just make the assumption that it's known that curbside voting is offered everywhere, but our membership is in favor of this bill again. And just have that one question about clarification, seeking clarification, last line of that added paragraph.
Members, are there any questions for Mr. Davis? None. Okay, I have my own question.
Sir.
Mr. Davis, when sometimes I see them where they're actually kind of a drive up, they don't use a parking space. It'll be they'll pull up next to the curve, or I've got a location in Baytown where there's a circle drive, and they do that there. Have you seen this as a common practice? And would that be in your mind as an EA something that would be considered as a parking space?
We've seen it. I personally, my county, we use it, and in my view, we think it serves the spirit of this bill and the spirit of curbside voting and in the code. We welcome any differing opinions on the committee.
Okay. I'd like to think that that word would be interpreted broad enough to allow for people to pull up next to something, to allow for people to walk the machines out. So
Perhaps even multiple vehicles behind each other in kind of a turn-based
yes,
process for curbside voting. Indeed, we agree, sir.
All right. Thank you. Members, any other questions?
Yes.
Representative Swanson.
I'd actually like to repeat his question about, I think he was unclear when it says it may not be. Does that mean it's okay if it's not? Or does that mean it's not allowed to be one of the same ones? He asked that question. I think he wanted that clarified.
I think that'll be a question for Vice Chair Gonzalez when she closes.
Okay.
Any other questions? I'm happy to answer.
Thank you, Mr. Davis.
Thank you, Mr. Chairman.
The chair recognizes Ms. Michelle Mostert. Okay, thank you, ma'am. The chair recognizes Christina Adkins. You want to come and explain this to us, ma'am? With the Secretary of State's office as a research witness. Ms. Adkins, if you could please state your name, whom you represent, and your position on the bill, please.
Good morning. My name is Christina Adkins. I'm with the Texas Secretary of State's office, and I'm here to testify on HB 478.
Members, any questions for this witness? I think it may be helpful. Ms. Adkins, how might you interpret, as someone with the Secretary of State's office who is, tasked with interpreting the election code, what would you think of the language that's been being discussed, that last line there, that the parking space may not be one designated specifically for persons with disabilities?
I would read may not be one designated specifically for persons with disabilities as prohibiting it from using one of those spaces. And I think based on the testimony, and I think based on Vice Chair's explanation, that was the intention, to make sure that those individuals that need to utilize those spaces, perhaps to use the facilities or vote in person, have the opportunity to use those designated spaces.
All right. Thank you, members. Any questions? All right. Thank you for your help. Representative Clardy, go ahead.
Thank you, Ms. Atkins, for your testimony. Just a simple question. It seems to me, and I appreciate the support of the Elections Administrators and Clerks Association of this bill, but it just seems to me that the last thing we want to do is micromanage decisions of how a particular location is administered or where you select one. And that would be my only concern about saying you may not use these places, because there may be situations, none of us have a perfect knowledge, but the elections administrators do, of their voting and polling locations. And there may be circumstances where the only place feasible to safely have curbside parking or curbside voting is in a place designated for a handicapped place. That would not be the optimal situation, and I think that would be avoided. But I think I'd like to have some discretion in there for elections administrators and the clerks who have more intimate knowledge to make that decision. There may be situations where, we can't put it here because it's right when you turn in, and so you have people backing up into traffic and create an unsafe situation. So the best place is in that handicapped where, and it has to be an accommodation, and I think people would make good decisions, and that's why we have good, competent clerks and elections administrators. Does that make sense to you?
It does, and I will add that the phrase parking space, given the way the Vice Chair kind of explained it, that it sounds like the intention there was to be broad in what parking space means. And so if you have a location that has, maybe a more appropriate place, like a driveway or a circular driveway, where they could designate or set up spaces there, that might also help provide some flexibility and help maybe alleviate some of those concerns.
That's the way I took it too, and I know that our vice chairman certainly thinks broadly on many of these issues.
Thank you.
Chair calls Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee. Neutral bill. Mr. Vera, this is your first rodeo. For the record,
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying on HB 478. This is a good bill. It's a step forward for voters unable to enter the polling place without assistance or without risking injury to the voter. We would testify for the bill, Vice Chair Gonzalez, except that HB 22 is about to come up, and that has even more for the voter. That's why we're on this bill. The one thing we would change, and Representative Clardy, this may address your issue, we would recommend to Vice Chair Gonzalez that if this bill moves forward, in that last line, we would change may to shall and make it prescriptive. And here's why. Harris County is now under a consent decree with the Department of Justice voting section ADA issues. We've been dinged again because we use so many schools and public buildings as voting locations, and the spots marked for handicap voting or disabled accessible are taken up all day by people doing business in the school or in the building itself. And so we've been dinged because voters who need this kind of assistance pull up and cannot find a place to park, have to wait for an hour or more for that space to empty before they're allowed to go in there. So we would recommend to Chair Gonzalez that you be prescriptive and say shall not be one of the marked spaces already in existence. That'll make it easier for the voters. I'll be happy to answer any questions.
thank you, Mr. Vera. Members, any questions? Thank you, sir. The chair calls James Slattery. Slattery. We're going to get it right, James. I know I'm going to see more than just this one hearing, right?
It was very close.
All right. The three things. Please let us know your name, whom you represent, and your position on this bill.
James Slattery. I'm here with the Texas Civil Rights Project testifying in support of the bill. Curbside voting is a very popular and very successful aspect of Texas elections, ensuring that those who cannot physically participate in voting in a polling place to the same degree as their fellow Texans can still vote. My organization participates in the Nonpartisan Texas Election Protection Coalition, which works to ensure that every eligible Texan can cast a ballot that is fairly and accurately counted. This good bill would address one of the biggest problems we documented during the 2020 election, which is a lack of curbside signage at many polling places and a failure to provide curbside voting at all at other locations. Most flagrantly, Bexar County openly refused to post curbside signage at all their polling places until ordered to do so in a lawsuit brought by TCRP and the Coalition of Texans with Disabilities. We would like to suggest one possible change that also might address some of the concerns that have already been expressed, namely that the parking space requirement, making sure that it does not unintentionally result in the closure of polling places that local communities have relied on, but which may not have sufficient parking to meet this requirement, such as college campuses. We would propose to the committee an amendment requiring each polling place to designate an area sufficient to accommodate one or more curbside voters, and that the route to this area itself be physically accessible to poll workers with disabilities and be adequate for the movement and stationing of voting equipment. With this change, we believe this bill will bring substantial benefits to Texas voters.
Thank you. Members, any questions? Thank you, sir.
Thank you.
Are there any other witnesses wishing to testify? The chair calls Ed Johnson, representing himself, neutral on the bill. Mr. Johnson, please state your name, whom you represent, and your position on the bill.
My name is Ed Johnson. I'm on the bill, and we need to say the bill number too.
You are representing.
I'm on the bill for 478.
Okay, and you represent yourself?
I represent myself.
Thank you, sir.
Got it all in there. This is a very big problem. I find when I was working at the county clerk's office, early voting locations and things, handicapped people had a hard time finding parking spots in a lot of polling locations. So it is a problem that needs to be addressed. I am on this bill because we're going to hear a bill later that is actually a lot better and actually in guidelines with the ADA. This bill is not in guidelines with the ADA. The ADA recommends 2 parking places per polling location, not 1. So if counties were to follow this, they're not going to be following the ADA guidelines.
Thank you. Members, any questions? Thank you, Mr. Johnson. This time, the chair calls Bradley Hodges. Thank you. Okay. If there's anyone else who wishes to testify on, for, or against House Bill 478? Hearing none. All right. Thank you. Representative Gonzalez, I recognize you to close.
Thank you, Mr. Chairman. HB 478 ensures voters who are physically unable to enter the polling place due to disability or health have easy access to their ballot. And I certainly want to work with the members, and I appreciate the feedback from the witnesses as far as language, just to clarify the language in the bill. So certainly we'll take that into consideration and work with members on the committee as well as other members to clean up the language. I mean, we want this bill to do, it's good intentioned, and so we want to make sure that we have the language right and everybody's okay with it. So with that, if there are no further questions from the committee, I will close.
Members, any questions for Vice Chair Gonzalez? Okay. Hearing none, if there is no objection, the chair leaves House Bill 478 pending. The chair lays out House Bill 22 and recognizes Representative Swanson to explain the bill.
Thank you, Mr. Chairman, members. I appreciate the previous bill, and I know we all want to work together on this. This is a very important issue to me. Some of you who come and testify regularly over the years may remember that my father was paraplegic from the time that I can remember, and many of those years were before the ADA, and so I'm very sensitive. I notice, even when no one's with me that needs it, I notice when places are not easily accessible, so it's very important to me. I became aware of this issue over the years, many years as being an election judge, and then a lot of years of campaigning outside of polling places, and noticing that many voters would pull up and they had no idea that such a thing as curbside voting even existed. So part of my point is to make people aware of it so they'll see these signs and know that they don't have to go in. The other point is, time after time, I would see people pull up and they would wait, and they had no way to notify the election officials inside that they were out there. And so as someone campaigning outside, I would have to put on a jacket and cover up my campaign shirt, put away my literature, and go inside and notify the election officials that they needed to come take care of someone who needed curbside voting. So this is very, very important to me. We need to make these places very accessible. My bill has left it requires it requires 2 parking places. I have left it flexible where those can be. As someone who's been through this for years, I do appreciate that in some places, maybe those handicap places stay full the entire time. Or maybe the people doing the voting, waiting for curbside, then hold up the spots for somebody who needs handicap places to go in the library. My thought was to leave it flexible so individual elections officials can adapt to that, but I certainly am open to making some sort of floor amendment or anything if that needs to be fixed. But I don't want to keep them from using those spots in a place where nobody else is coming other than voters, and perhaps those are the best spots. So another thing that is in my bill is there have to be signs. And I don't want the counties to spend a bunch of money on these signs. I know in Harris County, back when I was an election judge before I became an elected official and could not hold elections, we did get paper signs in our equipment, and we were supposed to mark those. And I would like to make that statewide. And we also got markers in our equipment, and my bill requires that a phone number be put on there. That way, the person does not just sit out there. They can call inside. I've left it flexible what phone number has to be on there because, again, in Harris County, in my past experience, every election judge received a flip phone and we could be called all day. So we all had different phone numbers that day provided by the county, and we could have put that number on there. However, in some small counties, I'm very aware things are very different from county to county. This is my third term on this committee. Perhaps they don't give out those phones, and the election officials may not want to put their personal cell phone numbers on there. So I've left it flexible. Those signs can come pre-printed with the elections administrator's number on there, and then the election administrator can call the personal cell phone of the election judge, whichever phone number works. I also do list that it has to be in large enough font to be easily read by someone in a car. I'm hoping that these things will really take care of these problems, and people will realize this service is available, and they will then also know how to contact the people inside the polling place. And at that, I am happy to answer any questions you have and respectfully reserve my right to close.
Members, are there any questions for Representative Swanson? Whoa, mic on. Members, any questions for Representative Swanson? The chair recognizes Mr. Fierro.
Thank you, Mr. Chair. Representative Swanson, I mean, these are two great bills that we're being presented today, so thank you very much for bringing this to our attention. My question is, and maybe this goes to a subject expert, but is there a requirement from ADA to have 2 handicap parking spaces available at all times or all locations?
I believe that is true.
Okay. Thank you.
Thank you.
The chair recognizes Representative Busey.
Thank you, Mr. Chairman. Representative Swanson, I like this bill. I have worked on a similar bill in the past, and the signage is really good. The only thing I would like to work on with you with this bill is, if we could get there, is to not just have a callable number, but a textable number. We've seen that done in counties where then people can text and it's quicker service. It doesn't slow down as much as they can get a text to come out, someone's there. So if you're open to that, it's just one idea, and I'd love to work with you offline on it behind the scenes. So with the signage, the numbers be callable or textable always, so then we can text in, and sometimes that can make it quicker on the staff to get out there and not have to have the phone call.
I think that's an excellent suggestion that I had not heard before. And certainly in the situation where counties are distributing phones, it would already be textable, but it would affect where they were calling into a central number, they would have to use a cell phone. And I think that's a great idea. Let's require that.
Oh, great. Well, I'd love to work with you on that. Thank you.
Sure.
Members, any other questions for Representative Swanson? Representative Beckley, you're recognized.
Thank you, Chairman. Yeah, I really like this bill. I like the signage, the added signage that's on here, and I was going to suggest the texting as well, because we can do like a Google Voice number. So I really am glad that Representative Busey. My one thing is I do have, the mix between rural and not rural. Sorry, I'm like having my coffee's not kicking in. Is some of my polling locations, like I know in our district, they don't have the ability for 2 spots. And so that's my only concern, is that they just don't have, when you go and you're standing at all the polls and you see that location just doesn't have it. Is there a way, and they probably are only like one precinct, they're the smaller turnout. Could we do it based on expected turnout, or something that they could opt out of the two? And I know that it's an 80, or you said it's an ADA, but they may take the spots that are already used. Because these locations, I don't have any polling locations that it's only used for polling. Like, they're always used for they're multi-use buildings. They're just polling that day. But the larger ones having two, I'm completely, or two or more I completely agree. Is there any way we could maybe work for like a set, if we only expect so many voters, or it's a smaller location, that we can maybe reduce it just in that case?
Thank you, Representative Beckley. I think that's an excellent question. My thought, and I'm willing to clarify, this goes along with what the chairman said. I'm very flexible on what these two spots look like. If they are the curb, if they are the drive-through. For a number of years, we had early voting at a church that had a very, very wide sidewalk to the front door, and they had made it accessible where you could drive up, and we would just send, it was 2 cars wide, so they could have easily had both spots right up there on this giant sidewalk that was the entrance to the church. So I think that if we're that flexible, 2 parking spots would be attainable by any location.
Thank you. Members, any other questions for Representative Swanson? None. All right. At this time, the chair calls Heather Hawthorne, County Clerk of Chambers County. And it looks like some other titles there you're going to tell us about.
I am.
Ms. Hawthorne, if you could please state your name, tell us whom you represent and your position on this bill.
Great. Thank you. My name is Heather Hawthorne. I am the Chambers County Clerk. I represent the county and district clerks of Texas. We are for this bill. Actually, there are so many great things between the 2 bills that have been presented this morning. Obviously, we know we can do better. Obviously, we can always do better. The signage is very important. I love your flexibility that it doesn't have to be some gorgeous sign. It can be a piece of paper with a phone number, because that's keeping it affordable in Texas counties. Additionally, Representative Busey, thank you for bringing up the text. As we all know, that there are counties out there that don't have cell service, that it's faster to text something than it is to actually call. So that was a great point. As far as the ADA, I'm aware that it's based on the number of parking spaces that you have at that particular building. So 1 to 25 parking spaces would be 1, 26 to 50 would be 2. So that's how that number comes about. And I'm assuming that this bill is 2 additional than the already designated handicap parking spot for the building.
That's not the way the bill is written. I'm open to if we need some more, but my bill leaves it flexible. Right. So a small place that they want to use those places, especially if there's nearby spots where it can just overflow. But I think that typically the election judge needs some flexibility there.
I totally agree. Being the one in the trenches, I totally agree that every poll is different in every precinct across Texas. So I appreciate this bill. I love helping Texans vote, and I recommend passage on this bill. Thank you.
Thank you.
Members, are there any questions for this witness? Thank you. There's a peanut gallery up here. Sorry. All right. At this time, chair calls. By the way, there's a lot of people wanting to testify for, so if any of you out there feel like the person testifying for it stated your point, it would be really nice of you maybe to pass, please. All right. At this point, the chair recognizes the great Glenn Maxey. He calls the great Glenn Maxey. Mr. Maxey, you know what to do. If you could
Glenn Maxey, Texas Democratic Party, and we're in support strongly of House Bill 22. Specifically, the signage and the phone number are a great addition. It'd be helpful. Another comment.
Members, any questions for Mr. Maxey?
Thank you.
Got it. This time the chair calls Alan Vera to testify on the bill. Good morning, Mr. Vera. If you could please state your name.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying in strong support of HB 22. This bill is a big step forward in the treatment of voters who are unable to enter a polling place without assistance or the likelihood of injury. Since, again, Representative Clardy, since so many polling places in Texas are at schools or other government buildings that are open for other business, there's historically been an unintended competition for available special parking. It's just the reality. Designating 2 spaces for voters who meet the qualifying criteria addresses this historical competition and helps ensure more dignified treatment of those voters who would be the beneficiaries of this bill. It also provides, thanks to phone calling or texting, thank you, Representative Busey, greater independence for voters who meet the statutory criteria, allowing them to gain access or assistance without having to bring their own helper with them. That, I think, is a big step forward. This bill makes it easier for voters to meet the criteria to exercise their right to vote. We recommend passage. Thank you.
Thank you, members. Any questions for Mr. Vera? Thank you, Mr. Vera. At this time, the chair calls Mr. Chris Davis. Mr. Davis, if you could give us those 3 pieces of information.
Thank you, Mr. Chairman. Members, Chris Davis on behalf of the Texas Association of Election Administrators for House Bill 22. Ditto to what County Clerk Hawthorne said. And we appreciate the author's willingness to include text into the communication. Representative Beckley, Google Voice is the answer. It's what several of our member counties have done. It's streamlined, it's low maintenance, it means one less phone call or phone ring that we have to handle in the office, and multiple folks in the office can staff that free and easy to acquire Google Voice account. The signs obviously would be a small fiscal impact, but on those signs we can ask the curbside voters to give us their make, model, color of their vehicle, give us the code designation for the polling place, and we know exactly who to reach out to as far as the poll worker team at those polling places. So we're in favor of the bill. Thank you, Mr. Chairman.
On. Slattery.
Yes, perfect. Thank
Excellent.
you. I appreciate that.
Mr. Slattery, you know what to do. We have 3 pieces of information we need from you for the record.
Yes. James Slattery with the Texas Civil Rights Project testifying in favor of HB 22. Not to repeat myself from the prior testimony, but curbside voting is very important for voters who need that accommodation. Just to expand a little bit on the problems that we documented last year, we published a report, which I've cited in the testimony, about many of the issues that curbside voters faced in 2020, which this bill would do a lot to address. The 2 biggest issues being a lack of curbside signage, informing voters, you have the right to curbside voting, here's how you access it, and also some polling places saying we're not offering curbside voting at all. In Bexar County, as I alluded to a bit earlier, when we discovered that there were not curbside signage at many polling places in Bexar County, we brought the issue to them, and they flatly refused to put curbside signage where there wasn't before. They said something like, if you want it done, do it yourself. So many of the organizations in the Texas Election Protection Coalition created our own signs and put them in front of polling places, which we were happy to do, but that is the county's job, and they should have done it. And we eventually sued them and won to get them to do it. We also heard of many polling locations not just in Bexar County, but throughout the state, that we're not offering curbside voting on some days, literally because they said it's raining, or we're just not doing that today. But the law is clear that it has to be offered everywhere. And so for both bills, but now that I have a little bit more time, just wanted to give a little bit more detail there. As with HB 478, we also want to propose here an amendment for just a little bit more flexibility to designate, have counties designate an area at polling locations sufficient to accommodate one or more curbside voters, and that the route to this area itself be physically accessible to poll workers with disabilities and adequate for the movement and stationing of voting equipment. One additional thing on the telephone number, we would also suggest a requirement that the phone line be staffed during all hours the polls are open, just so there's a telephone line, but it doesn't just go to voicemail at any moment the polls are open. With those changes, we also believe this bill will bring significant benefits to Texas voters.
Thank you. Members, any questions for Mr. Slattery? The chair recognizes Representative Schofield.
Mr. Slattery, thank you for your testimony. Let me understand a couple of things you said. So you had to sue Bexar County because they weren't putting out curbside signs, and this bill would mandate those. If they're not mandated under law, what was it, common law? What did the judge use to determine that they needed to do that?
I don't have the decision right at hand, but I think, there is at least an implication, right, that if you have the right to curbside voting, the right is not meaningful if the government is not telling you about it. Right. So this, by putting it into law, would clear up any confusion.
And you would, I presume, assume that if we pass this, every jurisdiction will have to do it. They don't get to waive it and make their own local rule.
That's correct.
And the other thing that you mentioned was you actually had local jurisdictions who didn't enforce curbside voting when they didn't feel like doing it.
The reasons varied. Sometimes it's raining outside and we don't have cover to do it, or the person that does curbside voting isn't here today at this location. So it varied from place to place, but I think the underlying theme was this maybe unstated belief that curbside voting is an optional thing for counties to give when the law makes it clear it's mandatory.
They said the statute, black and white.
Yep.
So again, you're not of the opinion that the local should be able to just waive that or make their own rules.
The law as it is right now is that it's mandatory.
So a voter in that jurisdiction should have the same right to curbside voting as the voter in the next county or 800 miles away.
Yes.
Thank you.
Great. Thank you. Members, any other questions? The chair recognizes Representative Clardy.
Thank you, Mr. Chairman, and Mr. Slattery, thank you for your testimony. And let me offer a countervailing point. I think we've heard from the Clerks Association, the people that run the elections throughout the state. I happen to be the only member of this committee that represents a rural district, 3 counties. I would tell you some of the what you want to do and what the bill's trying to do is a very good thing, but I will tell you there are certain circumstances, I can think of specific instances, where it's not practicable, it's not possible. So you want to have a mandatory phone line that somebody can pick up for a curbside voter. Well, I have polling locations where there is no mobile self-service. There is no phone available. So you can't have someone make a phone call and ask somebody to answer it if you can't get a cell signal. There are other things where you can think about, again, about access to the polls and signage, et cetera. There's no place to put a sign. There's no, so it's not a simple matter of taking a piece of paper and putting it somewhere. There's, unless, maybe there's a tree nearby somewhere you can put it on. So I would like to insert into the statute some language, and I think it's the right thing to do, but I think this should be admonitory and not required. And if perhaps with some language, if practicable, some language there, because I think all of the elections administrators and all the folks who work elections across the state of Texas want to make voting fully accessible to everyone, but they're also very smart, intelligent people who know their job and will comply if at all possible, but there are times they simply can't do it, and I don't want them to be in violation of a law that is a mandate when it's just not feasible. So I I think there needs to be some wiggle room, some leeway for the people that run the elections to make their best decisions and accommodate as best they can with the resources that are available. Does that make sense to you?
Yeah, and one thing I would say is that on at least whether it's practicable to put signs, I don't think I've ever gone to a polling location where I don't see at least electioneering signs. So I think there may be some polling locations where it's difficult, but the political campaigns seem to do it.
Well, I would invite you to East Texas, and I'll show you several places where you will not see a place to put a sign. I mean, there really are. There are a number, and trust me, we try to find places where you can put a sign, but they're just not there. And sometimes that's actually not a bad thing. It's one less place you have to try to get signs out. So, but again, I think leaving it with discretion and encouragement, admonition to follow this, well-intentioned statute would be good. But as Mr. Schofield said earlier, I too am on the lookout for unintended consequences, but particularly those that affect rural Texas and places where we do things a little different than you might in the city.
Members, any other questions?
I'd like to address that, but should I wait till my close? Because it's an answer to Representative Clardy. Okay.
Yes. Any other questions? Thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against this bill? Okay. The chair calls Ed Johnson. Mr. Johnson, if you could please state your name, whom you represent, and your position on this bill.
Ed Johnson. I represent myself, and I am for House Bill 22. I would think that if you have a polling location and you don't have at least 25 parking places, that would be almost in the voter suppression area. So 2 handicap parking places is almost a requirement for any polling location there. I would strongly recommend it. This is a really great bill. It does a lot of good things with the signage and all that other stuff. So everything would work out good. And I've worked numerous polling locations. A little story, you're at 658, and it's never just one car that drives in. It's always 2 or 3. Same thing with the handicapped voters. It always seems like it wasn't just one handicapped voter that pulled up. There were 2 of them or 3 of them. So you do need to have 2 parking places.
Any questions for this witness? None?
Thank you.
Thank you, Mr. Johnson. This time, is there anyone else who wishes to testify on, for, or against this bill? Hearing none, if not, the chair recognizes Representative Swanson to close on the bill.
Thank you, Mr. Chairman, members. I do want to address a couple of things for my fellow representative from the rural areas. And being on my 3rd term here, I'm very aware that things are different in different parts of the state. So I'm very flexible that we could perhaps come up with some sort of a floor amendment or something. 2 things. In Harris County, my only experience of actually holding elections, although I have campaigned other places, they were creative, and they always put a cardboard, not full cardboard, but a thing you could fold into a triangle, and you got masking tape, and that was like if your 100-foot mark or whatever you needed to post was going to be in the middle of a parking lot, which is the only place I can think of where it's hard to post because y'all have dirt and stuff and trees. So I'm assuming you mean, in the middle of a parking lot. That's the only thing I can think of. So they would give us these things that you folded into a triangle and you taped them down, and you could figure out some kind of weight to put on there. I've also seen many election judges put it on an orange cone or even some sort of a traffic light, sawhorse kind of thing. So I'm very open. I don't want any county to be out a bunch of money on this. I think it can be done. My other thing was that I forgot was I realized there are some places that don't have cell phone service, and we could allow, have a committee sub or something on the floor to allow for that. My thinking is to have the spots very close because Representative Clardy, last I knew, I think horns on cars can still honk in your area. So we could allow them to pull up and honk. Would that be acceptable?
We don't have horns on our horses.
Okay, maybe we can confer about that later. And with that, if there are no other questions, I'll close.
I just, Mr. Chairman.
The chair recognizes Vice Chair Gonzalez.
I just want to thank Representative Swanson for filing this bill. I think it's great, and as I mentioned to you last week, I want to work with you to align our bills to draft the best bill possible that we can.
Absolutely. Thank you for that. And I've been taking lots of notes. I want everybody to know that I value all the input. So thank you very much. And if there are no other questions, I close.
Thank you, Representative Swanson. I do expect that part of that exchange to be on Twitter very shortly. Wonderful. Are you okay? Yep. If there's no objection, House Bill 22 will be left pending.
Mr. Chairman, is this Mr. Jatan's first bill layout?
It is, and he wants to do it from up here on the dais.
Now, don't you think a man doing his first bill layout ought to go down to the well?
I join in that objection.
I tend to agree, but of course it's his choice, even though we're strongly encouraging him to do otherwise. The chair lays out House Bill 1128 and recognizes Representative Jatan to explain the bill from the podium.
All right. Thank you, Representative Schofield. All right. Good morning. Thank you, Chair Kane, Vice Chair Gonzalez, and members. I'm here to lay out House Bill 1128, which is related to persons permitted in polling location and places where ballots are being counted. House Bill 1128 codifies lists of people expressly permitted in types of locations. This includes polling locations, the ballot board meeting location, central count location.
Or, Mr. Chairman, could he please state his name and his position on the bill?
In current election code, there are over 20 references on who's permissive in the election locations, and only one reference to who is restricted and applies a penalty. That's Section 61.001. This bill seeks to strengthen that section and clarifies who is permitted. During last November election, my county judge had to be removed from a polling location on multiple occasions. He had no role in the process of conducting elections and did not need to loiter where people were actively casting votes. My district attorney assembled a task force of individuals to supervise elections. Armed individuals were not involved in the process of conducting elections and were not required by or requested by the elections administrator or election workers. Those individuals were relocating voters in the room where votes were being casted. District attorney and his task force members did not need to interfere with voters, but the election code was not clear enough to specifically prohibit their presence or actions, and the codes are so scattered and unclear that election judges and administrators did not feel confident in the ability to remove those individuals. Election officials from other parts of the state have voiced similar concerns. Our elections administrators and clerks have asked for clear direction in the code. They need clear parameters from the legislature so they can admit everyone who should have access to voting, technical assistance, security, etc. And election judges should have the confidence to remove people who should not interfere with elections and attempting to intimidate voters. House Bill 1128 also introduces a misdemeanor for the violations under this code. Members, since this bill was filed, I've had several individuals reach out and have conversations about that they would lose access to polling facilities if this bill went into effect. Those individuals, I asked them where in the statute they currently had the ability to enter the polling location, and it was determined that they did not actually have access and were authority to enter those polling locations. Access to polling locations needs to be codified. The process of participating in elections should be transparent. It should be consistent from one county to the next. It should be enforceable, and it should be fair. House Bill 1128 is one step towards making that happen by codifying which people should be able in election facilities. And so I'm available for any questions. Otherwise, I reserve the right to close.
Members, I couldn't imagine that anyone has any questions for Mr. Jeton, but with that said, do members have any questions for him? The chair recognizes Representative Swanson.
Thank you, Representative Jeton. And we welcome to the Texas House and your first bill layout.
Thank you.
I think it's an excellent bill. I think this needed to be clarified. The one question I have, and perhaps it's already legally okay, but I wanted to clarify that we didn't end up causing a problem. Since you've defined that these people can be in the polling place from preparation time all the way till everything's finished and they're locking up and leaving, I want to make sure that we don't take away the election judge's ability to require voters and their children and their assistants to leave once they voted, because we certainly can't have 200 people still hanging out there all the way till 8:30 that night.
Right. I agree and understand. That's something we did run by some other attorneys. I wanted to make sure that our bill would add to the list of who's permissible, but it does not change the fact that there are other parts of the code that still determines when what hours they can be there and what they're allowed to and not allowed to do in the polling location.
Okay, but since you described some of that and say when all they can be there, I do have a little bit of concern whether we are now including voters, their children, and their helpers in the set that, that it'd just be impossible to run an election place if you couldn't have all those people leave after they voted.
Right. I definitely understand the concern. I'm willing to have more conversations with those that are going to implement this and have to rule on this. It is still my understanding that because it's specified in other parts of the statute that we'll be fine on this.
Okay, if you wouldn't mind doing a little more checking and perhaps making a floor amendment if it's needed.
That works.
Thank you.
Chair recognizes Mr. Clardy.
Thank you, Mr. Chairman, and thank you, Mr. Jeton, for bringing this bill. I do see where you have a provision in there where A14, the person admitted to vote can enter into the site. Have you made any provision, given any thought whatsoever, to the horse that they rode in on?
I have, and I think that the horse would have to stay out in the parking lot, in that designated spot. Yes.
And there's no provision, speaking of animals, for service dogs or other creature comfort dogs. Have you given that any thought?
I have not, but that is a good point. I don't think that this would impact any of the...
Do you have some sort of prejudice or discriminatory intent against our four-legged friends?
No, and I believe there are federal laws protecting them as well, and other state laws.
And a last question for the moment. The intent is to keep people from wrongfully being in the area that voting is taking place. What is the enforcement mechanism? I mean, what happens when this? I think it's to empower elections officials, the folks that have control or authority over those locations, to actually have someone expelled. Is there a mechanism in here that directs them how to do that and to do that safely and to avoid a breach of the peace? Because that's a very serious risk, and I think that's the last thing we want to have in our voting places. So is there a description of how that is done, how that's coordinated with law enforcement, what if there's any criminal penalties or sanctions that kick in as a result of a violation of those laws?
Sure. So 61.001 makes it a misdemeanor if they're in there unlawfully. And so based on that, I think that law enforcement would be able to be called out to enforce the statute.
And if someone is wrongfully attempted, if someone is trying to be expelled, an official tries to expel someone who is rightfully in that area, is there any recourse that that individual has when they're expelled improperly or without cause?
I don't think this changes the current situation of them being able to, if they're rightfully allowed in there, then this bill wouldn't impact their ability one way or the other, I don't believe.
you think perhaps we could, we need quick resolution of this rather than waiting for law enforcement to arrive. Have you considered having an arm wrestling contest? Whoever wins gets to stay.
We can consider that.
And we need you to think outside of the box. I know it's your first session here, but I'm expecting more from you, JC.
I appreciate that. I'll work on that.
Members, any other questions for Mr. Jeton? Recognize Vice Chair Gonzalez.
Thank you, Mr. Chairman. I have a couple of questions. Sure. Does your bill prohibit staff from elections administrative offices who are not technicians from entering the polling place on election day to conduct their administrative duties?
Sure. So based on my research, currently, even all the way up to elections administrator, would not be permissible in a polling location or the ballot board area or the central county unless they were performing an action, either technical action or dropping off supplies. Those individuals would not be there to loiter or to provide another layer of supervision. They would be there for one of those two purposes, which is in the bill.
So
they would still be able to, as long as they are either acting as a technician or dropping off supplies.
Okay. Would it prohibit staff from a county attorney's office from investigating a concern at one of the polling locations?
I believe so. The county attorneys, I would need to do more research on that, but I believe it would, because the investigation would happen outside of that, work with the elections administrator's office, and I think there's different recourses for and rules for investigation. But this would codify on a typical normal situation who's allowed and not allowed in there.
Because in the way that I read it, it would prohibit these folks from entering there if they're investigating a concern happening at the polls.
Okay. I'll have to look more into that.
Thank you.
The chair recognizes Representative Schofield.
Hi, a couple of points, Mr. Jeton. These are serious points, it's all right.
Okay.
The first thing is, with respect to Ms. Gonzalez's question, this is the election code. There are other laws. This doesn't say a police officer can't come in and arrest somebody who shoots somebody in the polling place.
Right.
This is just Chapter 61, which says basically who's allowed to participate in the voting process.
Right.
It was also asked by somebody else if there's an enforcement mechanism, and you're amending Section 61.001, a violation of which is a Class C misdemeanor.
That's correct.
Right, so you're just inserting this section into your subsection into that section, and so that would bootstrap to
Yes, sir.
to subsection D.
Yes, sir.
Okay. Thank you very much. I appreciate you bringing the bill.
Thank you.
The chair recognizes Representative Clardy.
Thank you, Mr. Chairman. And to Mr. Schofield's point, I knew that, Mr. Schofield. I just want to know if he knew that. But following up on Vice Chair Gonzalez's questions, I do think it would be appropriate with two questions. One about a state or about the investigative group, a DA, a county attorney investigating some crime, or presumably an election crime. I think that would be covered, but may need to be amplified or clarified in A1.3. A state or federal inspector might encompass that, but that might need that's a good clarification. But I do think it should be clearly stated. You seem to want to put some restrictions on the EAs or clerks in their ability to go monitor the very places that they're exclusively responsible to run and control. So I would have no restrictions whatsoever on, and I think there should be an addition that for elections administrators or clerks or election officer responsible for that county and their staff to be able to go in. On elections day, it's been my experience that they're not loitering or standing around, but they do go in and just check on supplies, walk through. And in some things, just as gracious as making sure there's waters in the back for the people working polls. So I think they should have unfettered access to the places that they control because they're too busy trying to run the election to be bothering people. And it's also important, I will say, for some, I'll use the word policing, but there are times that I know elections administrators or the offices get complaints about some situation within a polling location. And the best way for them to run that now is to actually, they are the boots on the ground to show up, walk through, and see if they can verify any of these complaints before any other action is taken. So I think we really should expressly provide them access to the polling location.
Okay, I think those are good points. The only thing I would state is that currently in statute, it doesn't appear that they would have that authority at the moment, and so I think that would be additional authority that they would have, which is I'm not opposed to, and I understand the concerns with that. So
If I don't get that, I'm going to kill the bill.
okay, I appreciate that. It's good to know. the horse. Okay.
Wow. I feel like part of me was inside of you just then, Clardy, and I like it. Yes, entertain. Members, any other questions for Representative Jutan? Chair recognizes Representative Schofield.
Mr. Jutana, I understand Mr. Clardy's point about the EAs and all that. I don't think voters are going to feel intimidated by the EA or their staff being in there. But didn't you have a situation down in your county where the DA was accused of sending in armed investigators and were intimidating voters? And is that something we want to put unfettered access to that in your bill?
Right, and I think it is important to make sure that we are limiting the access to the polling locations. And I think, going back to what you're talking about, when we're talking about our poll workers, our election judges, our alternate judges, the clerks in there, if we're providing them with the training that they need and the tools and resources, then there isn't a necessity for the elections administrator or clerk to necessarily need access into there, because they should be properly prepared before they enter there with the training and supplies. But I think there's some wiggle room there, but I do think it is important that we are, when it comes to law enforcement, the district attorney's, county attorney's office, or whatever it is, for them to send someone into those locations, it should be based on another area of the statute that gives them authority, because they're doing an investigation, they're performing some law enforcement process or investigative based on another section. I think in here it is important to keep that pretty tight.
Okay. Chair recognizes Representative Beckley.
Thank you, Chair. So, kind of piggybacking on Representative Clardy, talked about horses and companion dogs. Well, what about a companion emu?
A companion emu does not have 4 legs, I guess.
No, it has 2 legs.
So if it is protected somewhere else in the state or federal statutes, I'd be in favor.
Just checking.
Okay.
Thank you. The chair recognizes Vice Chair Gonzalez.
Back to what the comment you made just
sure.
a second ago, as far as county officials, right, their ability to go in there and investigate. And I know in Dallas County, we have an investigation unit solely, right, for election integrity unit. And so that's part of their job, right, to go is investigate any issues that are going on at a polling location. And so this would prohibit them from being able to enter a polling place if there's a problem going on there.
Well, I think if there's a problem going on there, in subsections, what is it, C or 10, we do allow for the election judge to have some flexibility in there to allow specified people in there. And so if there is a issue going on in that location, then that is covered still. Based on other areas of the code. So subsection 10, a person whose presence has been authorized by the presiding judge in accordance with this code. And so if there is an investigation or there are issues going on at the polling location that needs an investigation, they would have the ability to allow them in.
And so if the presiding judge said, no, I don't want you to come in here, then they wouldn't be allowed to go in there and investigate. So the discretion is solely within the presiding judge that's at each
That's
location.
correct. Yes, and they have a lot of that authority as it stands right now.
Any other members? The chair recognizes Representative Schofield.
One thing I want to point out about the bill, while this lists people who have an unfettered right to be there, again, it is going into Chapter 61. Current law in 61001 prohibits anyone from being in the polling place from the time the polling judge arrives there who isn't allowed to be there by the code.
Right.
So you don't have, we'd have to give an investigator a specific right to be there. The codes, unless they have the law enforcement capabilities from the penal code or some other area. So the current law already says if the code doesn't say you have a right to be there, you don't. What you're doing is laying out the list of some people who have an unfettered right to be there.
That's right.
That's what your bill does.
Yes. Thank you.
The chair recognizes Representative Busey.
Thank you, Mr. Chairman. Representative, I appreciate that you're trying to clarify who can and can't be around. Most of my questions, I think, are going to be to some of our witnesses about who else we think should be included on this list. I do appreciate also that you added a specific example you had with EA. Maybe one thing we can consider, so you can get Clardy's vote, as he so specifically articulated, looking at behaviors that would be banned by these people as opposed to just banning, the individual outright. And so I think most of my questions will be to some of our witnesses on what other people we think are being left off this list that we should include. That's really it. I think with that specific example, which is good because we've been asking for examples on a lot of bills today. We just don't want to throw everybody out because somebody, may have done something. So maybe we could look at a different way to enforce that behavior. But I appreciate it. Thank you.
Any other questions, members? Thank you, Mr. John.
Thank you.
You're allowed to come back up here if you wish.
Thank you.
Yes, he's authorized. The chair calls Eric Oppiella to testify on this bill. Mr. Oppiella, if you could please state your name, tell us who you represent, and your position on this bill, please.
Thank you, Mr. Chairman. Eric Oppiella representing myself, supporting Representative Jaton's bill. I think it's a great codification of what we currently have in the law, and it gives the election judges some ability to deal with loiterers. Right now, it just says they have the ability of a state district judge to preserve the peace at the polling location. Okay, so this adds that criminal penalty that really makes it clear that those people who are loitering shouldn't be there. Before we start adding other people who are not currently authorized in the law to be there, I think we need to think very clearly about some abuses that might occur as a result of that. I respect Representative Clarity's sentiment that election workers who are employees of a county clerk's office might have a reason to be in the polling place. However, it's been abused. Just this last election cycle, a partisan county clerk in Harris County appointed partisan attorneys to serve as minders for election judges and clerks of the opposite political party. And we had to, I was working with the Republican Party, had to make clear to them that we would seek an injunction to make sure those people didn't appear on election day to harass the election judges and clerks of the opposite political party. And so we need to be very clear that if they're not performing a duty that is specified in the code, they really shouldn't be there to be loitering and harassing those people. And if they are needed at the polling location, the provision in Representative Jaton's bill makes it very clear that the presiding judge can authorize them to be there to assist them in performing their duties. And I think that would serve to fulfill that need that you identified without creating a situation for abuse by, unfortunately, sometimes we have election or county clerks that abuse that privilege based upon their partisan position, and that's not appropriate. So before we go and explore adding other people who are not in the code, which Mr. Jaton's bill does not do, he just codifies the existing law, we need to think very clearly about that. Thank you. Any questions?
Thank you, Mr. Oppiella. Members, any questions? Oh, you're not free yet, Mr. Oppiella. Yeah.
Oh.
Yeah. The chair recognizes Representative Clardy.
Go ahead. So fast, Mr. Oppiella.
Yeah.
And while I appreciate your comments, I got to make this observation that the people you're talking about limiting their authority are constitutional officers of the state of Texas. They are duly elected officials. They have taken an oath of office and have sworn to uphold their duties as county clerks or election administrators. So I don't take lightly our responsibility or, frankly, our authority to impose additional restrictions on other elected officials who are doing those jobs. Now, there may be some problems in other places, and with all due respect to this committee, I think the vast majority of whom hub out of greater Harris County, the sun doesn't rise or set on Houston. And there are other places in the state where we don't have problems like this.
That's
And a big part of my job is not have big city problems and trying to fix a problem. And I'm not saying there's not legitimate concerns, and I respect the members who have told me some of the stories or experiences they've had in Houston or Harris County or wherever the case may be. This applies across the board, not just election offices, but too often the rest of the state suffers unintended consequences being imposed because of a problem that we don't have and create problems we never wanted. And so, I think that there are other recourses and remedies, and it sounds like in that situation, to the extent that there was any wrongdoing or malfeasance or improprieties by anybody in Harris County elections, it sounds like that was actually addressed in the moment, at the time, through other judicial processes. And it does require us changing the law, which would have an effect, and I think an unnecessary and unwanted effect on people that I trust to do their jobs, because they've proven to me they can do their jobs quite well across Texas, and those are our election officers and our EAs.
And I agree wholeheartedly with you, Representative Clarity. And Representative Jeton's bill doesn't do that. He just takes the existing law and codifies it, takes all these different provisions, which are kind of hard to find. And the Secretary of State has actually created a manual where they identify all of these provisions. And that's where he got that information from that's actually in the bill. And puts it in one convenient place where people can understand that. I do understand your concern about that. Unfortunately, we have 254 counties in this state, some of which are larger than half of the states in the nation, specifically the county we were just talking about. And so I think that the concern that that we have about that is addressed by the provision in Representative Jeton's bill that the presiding judge, and maybe it's appropriate to have the alternate presiding judge also be part of that process so we don't have a partisan process there. So if they both agree that they need help, they can get that help from the election staff. And
this is a proposal of hiring good people, which is what the voters of Texas do, and then allowing them to do their job. So,
yes.
Again, I'm going to be opposed throughout this session to micromanagement of people, at least in my part of the world, and I think throughout Texas broadly, that work hard, do their job, and can be trusted.
99% of our good, hardworking election officials are in it for the right reasons, and we need to applaud that work and encourage them to continue that good work on behalf of the people of the state of Texas.
On that, we are agreed. Thank you.
Thank you.
The chair recognizes Representative Schofield.
Before we get too far afield, let's focus on Mr. Jeton's bill.
Yes.
Right. Under the current law, and I understand that you know the code backwards and forwards, but I'll still, for the sake of everybody else, under Section 61.001 of the current law, no one's allowed in an election place except as permitted by this code.
That's right.
Correct?
They would be loiterers.
So the example that you gave of a minder that somebody wants to put in to oversee the other side's people, that's not permitted by the code.
No, it's
correct?
not.
So Mr. Jeton's bill does not impose doesn't tell them they can't be, their current law does. Doesn't tell an EA who they can and can't have in there, current law does. All his bill does is say these are the people who the code permits.
That's correct.
And takes it from other sections. Again, the current law says, except as permitted by this code, you can't be here. And then in Section A1, he lists who those folks are. He's not barring anybody who's currently allowed. And so far as I can tell, he's not allowing anybody who's currently barred. He's just stating these are the folks who are allowed in the building under the code the way we've set it up.
Well, the only point I disagree with you on is he actually is allowing the discretion of the election judge to allow someone, that's not in the code right now, where even if they need help, they can't, under the current code, allow someone who's not allowed to be in the polling place. Now, perhaps in their discretion, as it says, as a state district judge, the legal standard for appeal of a decision of a district judge is abuse of discretion, right? And so I could see how perhaps that does codify that standard that we have in the common law.
So what you're saying is he's not barring anybody who's currently allowed by the code, but he may be allowing some discretion that I'm sure Mr. Clardy would like to see.
He does not change the substantive law of the state with regard to who is allowed in a polling place.
Thank you.
Yes, thank you. Members, anything else? Your testimony is very helpful. Thanks so much. The chair now calls Marcia Strickler. Marcia Strickler representing herself against the bill. Marcia, if you could please state your name, whom you're representing, and your position on this bill.
My name is Marcia Strickler, Williamson County. In this particular bill, I am against the bill because I'm here to actually learn a
Ms.
little
Strickler, are you representing yourself?
bit myself.
Okay. And your position on the bill? You say against?
I'm against.
Thank you.
Yes, sir. I'm against. Yes, I'm against the bill at this point. I may not be against it when we're done here.
For purposes of today, ma'am,
Yes,
you were
sir.
testifying against the bill.
Yes, sir.
Thank you.
I'm testifying against the bill as I understand it today.
All right.
I may understand it differently tomorrow. I believe that we already have election code law that covers what Representative Jetton is asking to be done, but perhaps, so it seems to me to be a bit redundant. A lot of the same thing is being discussed here, so perhaps there is a need to have more strengthening of language in the bill for understanding. On Election Day, I am one of those field tech support reps that work in my county and support the election department under Chris Davis in Williamson County. So I support several polling locations throughout my county. I review equipment, I bring supplies. I am one of those people that show up to support the judge and the polling location and the election opportunities. There are also things that I have experienced in that capacity, as well as a voter capacity, that goes on in polling places that addresses what I'm hearing here today. One of our polling locations, for example, had a judge who brought a husband with her in the morning to help them set up equipment prior to the election starting. And that is not allowed in our county, apparently. So that was something that was brought to the attention and said, we can't do that. So she's no longer able to do that. We also had some people show up to help clerks at the end of an election, shut down equipment, get it stored, carry it out, things like that. And I think what I'm hearing is that would not be allowed. And maybe it's not allowed today. Okay, so I'm against changing anything that's already in the code that is already being addressed. So if I can find something in this hearing today that addresses, and to Opiello's, Mr. Opiello's comments about taking all of this and codifying it together in a manual that Secretary of State has that is already existing that I'm not aware of, and if I could understand what those are, I may have a different position. But right now, I'm against this bill for various reasons. I'm against changing existing election code that's already addressing this, and this seems to be redundant to me.
Thank you. Members, any questions? Hearing none. Thank you.
You're welcome.
This time, the chair calls Michelle Mostert. Thank you. This time, the chair calls Bradley Hodges. Hello, Mr. Hodges. If you could please just make sure I think we've all heard it, but please state your name, tell us who you represent, and your position on the bill.
Representing self, Brad Hodges, on the bill.
Okay. I've got you shown as being neutral, so it's on?
Neutral.
Great.
On.
Thank you.
Okay. Question for the chair, for Mr. Jetton. What does this bill do to protect and preserve the objectively reasonable access of poll watchers to witness the count, right? And that's to preserve the chain of custody integrity, or the integrity of the chain of custody. So the reason I'm asking specifically is Travis County, last election, putting the Republican watchers in the holding cell, right? So they could witness, right, the count, but not witness it. That seems to me a little conflict there. So just a question on the table. You don't have to answer to me, but that's my concern. So the other one is, I'm just in general, this bill, what does it do to address the overall integrity question, right? So I think that it would be better for everyone involved to comply, let's say, for the same policies, practices, and procedures that banks use when handling money, right? Should also apply to anyone who touches a ballot, right? Is our money more important than the ballot? No, the ballot's more important, right? Well, Chase Manhattan, for example, I think it's the ¡1 target of fraud in the world, and they use they have regs, internal regs, to check that, because they have to, because if they did, they'd be overrun. So I was a poll watcher last election. I did not see a single, I'm just speaking for myself, I did not witness a single instance of voter intimidation. Not one. I'm not saying it doesn't happen. I didn't see it. I did see multiple attempts at fraud. Okay? Now, we caught it. I can go in specifics if you prefer. The point I'm trying to make is the system works when you use it, right? And how do you use it? You need the poll watchers who are certified by the candidates, in my instance, right? So that you can, if there is a problem, I have my little notes and I can testify to that after the fact, right? So that's really important. I would, on your bill, I would maybe you might consider adding one word in there in the end to your. So at the very last section, you have watchers are listed as one of the persons who are. Here, let me read you the section number to be specific. Okay, so you're going section 127008, bystanders excluded. So you've got the election judge, their people, right? Legit. Technician, as authorized. Person whose presence has been authorized. Who's not authorized is the watcher, number 2 there. How about add in certified watcher to reflect the fact that we are, in fact, certified as witnesses by. I didn't go through the party. I went through my candidate specifically to be there because she couldn't. Okay? And again, I'm glad I was there because I can testify that, yes, our precinct's clean. I saw it. They tried fraud. It didn't work. We caught it.
That's it. Thank you, Mr. Hodges. Members, any questions? Thank you, sir. All right. At this time, the chair calls Dr. Laura Presley. Dr. Presley, if you could please state your name, tell us with whom you're representing, and your position on, for, or against the bill.
Yes, Dr. Laura Presley. I'm representing myself and also our Joshua Council Texas Election Watcher Coalition.
And your position on the bill?
Against. So, Representative Jeton, I really appreciate the intention of this bill. My opposition is more structural with regard to how the wording is. Just a couple of things I want to bring to your attention. Under 61.001, you use the language is there of preliminary arrangements. If you look at and I'm going to look at this from the perspective of watchers. So watchers, if you look at the watcher code uses a little bit different language. They say preparing to process. So preliminary arrangements and preparing to process seem like the same thing. But what I would do is maybe my recommendation is put both of those types of text or language in both places so that there's no confusion. Okay? So the Watcher Code 33.052, so they're just, those are two different sets of language, 33.056 also. in the Watcher Code. You might want to be consistent on that language. The second thing is, I love how you put election day and ballot board and central count. You may want to also add this similar sections to early voting, the early voting location, also the recounts. Similar, those are, you've got watchers in both places where people are authorized to be. So I think if you want to, do this thoroughly, you might want to add early voting and the recounts. The last thing really has to do with adding the people that Representative Clardy and Busey were talking about. I think the alternate presiding judge probably should be added in each location. That's probably the right thing to do. And if you go to your language in 127.008, bystanders excluded, you add the language of, in a central counting station while ballots are being counted, actually a watcher is also allowed to be there when those preliminary arrangements and those preparing to process is being permitted. So I don't want to think that now this is conflicting with the Watcher Code, where the Watcher Code allows the preliminary stuff and this one may not. So mostly it's structural. I love the idea of putting this because election code there's so many, the code is all over the place with regard to where things are. And this I do think will help deal with issues that our watchers have been dealing with for many, many years. And Representative Clardy, you asked a question about the consequences if these people are obstructed from these activities. The Watcher Code 33.061 is a Class A misdemeanor to obstruct them. So that helps a little bit. Okay. Thank you for this. Appreciate it. Any questions? Thank y'all.
Mr. Chairman, my name is Bob Green. I am the chair of the Travis County Republican Party Election Integrity Committee. I've had the great pleasure to speak with several of your people, staff members, and everything in your office and discuss many of the issues that will be coming up here. Today, Dr. Presley touched on one of the things that I was going to speak about because I've handed out some written testimony with regard to amendments in the bill to add the alternate judge as well to the someone who would be authorized to be present, and also to authorize another individual to be present in these facilities when vote counting is going on. I have been a precinct chair and an election judge here in Travis County for about 10 years now. And I have seen irregularities, yes. And I think that any legislation that this committee passes and that this House passes and that eventually becomes law should make it very, very clear that this is one of the most important issues we are facing in this legislative session. I realize we have the 600-pound gorillas with redistricting in the budget, but behind that, I think this is that important. I would like to throw in something that came up. Representative Swanson mentioned earlier, and I thought about it after testimony had closed. Had you consider having a clerk be assigned to stand outside to watch for people who might be showing up? Oh, okay. Well, I just thought that might be an option, Yes, I am the same person. As both the presiding judge and the alternate judge have the powers of a district judge during their appointments, both should be given essentially the same authority to authorize the presence of an individual in accordance with the code sections referenced in HB 1128. And if you have any questions, I'll be happy to try and answer them.
Members, any questions? Thank you.
Thank you.
Mr. Green. That was a 4. All right. This time, I'd like to call Ms. Heather Hawthorne, the Honorable Heather Hawthorne. Ms. Hawthorne, if you could please state your name, tell us with whom you represent and your position on the bill.
My name is Heather Hawthorne. I'm the county clerk of Chambers County. I represent the County and District Clerks Association of Texas, and I am for the bill. Concerns with the bill are that adding the alternate judge, I'm in there, I'm in the ranks, I'm up going at 5 o'clock that morning, and then bam, somebody has the flu or COVID or whatever it is at this point. And we need to make sure that the alternate judge is included in that, just for pure practicality is really what that is. And also, adding the county election official, I will tell you personally that our presiding judges obviously welcome us. They turn in their paycheck, their time to me. I pay their paycheck. The county, the tax dollars pay their paycheck, but they turn in their timesheets to me, and I'm their boss, and I'm hiring them, and I'm giving them instruction, and then I can't even go into the polling location. But I'm for this bill. I love having a list of who can be there and who can't, and I want to remind everybody that there are 253 other counties besides Harris County.
Yeah, thank you, Mrs. Hawthorne, for reminding us all that. But it's really important to know that a few counties that do crazy things, the excuse that a majority don't does not mean that we must address the others. And when I'm reading it, I don't see how it doesn't exclude you guys. The judge is allowed to authorize you to be there, isn't it? When I read that bill.
You are correct.
Okay, awesome.
But I hate to have to get
Judge doesn't
permission.
like you, though, they should be able to exclude you, I would think, right?
No.
No. Well, I didn't really think these were public places, and they should only be authorizing people to enter there that should be there. If you have no business other than dropping off ballots, no one should be walking around it. And that includes whether you're a police officer, an armed guard, a government employee, or me, period, whether I'm not on the ballot. So I really trying to understand why election administrators or their staff are concerned that they should be there doing anything other than the business. And if they're not there for business, if it's just pleasure to walk around and say howdy and check on people, I'm trying to understand why we should be present.
Right. And so in the defense of the election officer, that a lot of times, Chairman, I'm making sure that the postings are up correctly, that, our poll workers in the state of Texas are aging. And so we want to make sure that as the elections officials whose name's on the door to run these elections, that things are done properly and from the get-go, and make sure. So, our staff is there at 5:30 in the morning, and when that presiding judge arrives, we're there to help and assist and unload equipment and make sure the postings are in the correct place, and make sure that they have signed a paper ballot if they need to. And it's just not for counties. It is for school district elections and other elections that are involved, other poly subs. And so I just want to make sure that we have the authority to be there. And, of course, this is only on Election Day because we're allowed to be there during early voting.
For now.
Yeah. So anyway, that's all I just wanted to make. My thing is mainly alternate judge and secondly county elected officials.
Well, it doesn't sound like we're too far off.
We're not.
As long as y'all are wanting to be there in order to do something that's assisting and we're not there for small chat.
No.
Great.
I have many other things to do on Election Day.
Members, any questions for Ms. Hawthorne? Of course. Representative Clardy.
Thank you, Mr. Chairman. I just wanted to confirm, if I heard your testimony correctly, you're the boss.
I am the boss.
Yeah.
If you don't believe me, you can ask Sheriff Hawthorne.
I'll ask the sheriff about that. I'll ask the sheriff about that. Because that's an interesting concept. If she's not there properly and they call law enforcement in Chambers County, the sheriff will have to physically remove his wife from the election.
Stop.
Actually, I'm coming to like this idea a little bit more, Bristol.
Same wavelength. Thank you, Mrs. Hawthorne.
Any questions?
Any other questions? Representative Swanson.
Thank you, Chairman Kane. as somebody who works in, you're right there in the field. What a person brought up that somebody's husband helped them, and as a small woman who's held many elections, I have used my husband. I've used my kids who were not 16 yet.
Darn
at that time,
right.
But boy, they could sure haul tables, set up election equipment far faster than any workers I had. We were not opening the machines because, of course, we didn't do that till the next day. Everything was still very secure. What do you feel like this would keep people from helping with the basic setup, such as hauling tables and getting the machines in the right spot in the room? And if so, how would you fix that? I realize if they were adults, you could sign them in as an unpaid worker. I couldn't have done that with my minor children. If you could just address how you think this would affect that, because again, you said we have older election judges, and we can't be expecting them to haul tables around and swing those machines around.
Yes, ma'am. So again, the phone rings at 5:30 on election day morning, and I mean, there's a lot to do, but setting up a polling station, but we don't want to prohibit people from wanting to be election judges or alternate judges or clerks because they can't get any help. That according to the law, it says that X, Y, and Z are the only ones allowed in the polling location. We don't want to prohibit or discourage anyone from being a poll worker because it's hard to get poll workers.
The answer would be to sign the person in and make them a
Exactly.
Okay.
Exactly. And it's all permissive as long as the presiding judge says yes.
Yes. Okay. Thank you.
Yeah.
Thank you. Members, anyone else? Thank you, Ms. Hawthorne.
Thank you.
Members, I do want you to know, and I'm not calling you Mr. Ingram, but I will be having Mr. Ingram up last, so if you have any kind of these technical questions to be thinking about, reserving those for Mr. Ingram. At this time, the chair calls Mr. Glenn Maxey, Texas Democratic Party, showing neutral on the bill. Mr. Maxey, if you could just restate what I just stated, letting me know who you are, who you represent.
Glenn Maxey, the Texas Democratic Party, and I'm testifying on this bill. I agree with the thrust of the bill. My concern is around the issue of the election administrator or clerk or their staff being in a polling place. As the primary director of the Democratic Party, I can tell you, I'm hearing us talk about today that election administrators and clerks are not currently allowed to be in a polling place. However, my reality is during our primary, I have county chairs who have contracted with election administrators and clerks all over the state, and those election administrators and clerks do go in polling places to solve problems and assist in dealing with things. So perhaps this bill needs to define that thing a little more. The piece that says they can be there upon the invitation of the election judge is accurate. However, the statute actually says that the election administrator, with the agreement of the party chairs, can remove a election judge that is there that may be violating the law or might be inebriated. These are not examples that I know of. Well, actually, these are examples I know of occurring, of people who are just out of control, high on drugs. I've seen it all over the years. And so that election administrator has the authority to remove that person with our agreement. And I think with this bill, now that we're making a list, somebody could say that they couldn't be there to do that thing that they're authorized to do. So I just want to make sure we clarify what those election administrators and clerks who are, as my good friend Heather Hawthorne says, they are in charge by law or by contract.
Great. Members, any questions for Mr. Maxey? Thank you, Mr. Maxey. At this time, Chair calls Lisa Nielsen. Hi, Mrs. Nielsen. I show on my end that you're here representing yourself and that you're for the bill. However, for the record, could you again tell us your name, who you represent, and your position?
So once again, I am Lisa Nielsen. I represent myself. And I am, in principle, supportive of this bill, but I do have some caveats and some
So
suggestions.
just to be clear, but you're here testifying for, against, or on? For.
For.
Okay, thank you.
But I would like to make some suggestions. So first of all, I just want to let you know that once again, I was a poll watcher in Central Count in Bexar County on November 3rd. In addition to that, I was a watcher of the recount of the Tony Gonzalez and Raul Reyes race for Congress that happened in Bexar County in August of 2020. And based on that, I've had a few experiences in watching the process and learned quite a lot about what works and what's not working and where some of the areas of integrity are being compromised. And I really appreciate some of the suggestions that we've already heard here, and I want to explain those if I can. I want to say that I agree, I'm not exactly sure who said it earlier, but election integrity may be the most important thing that you all deal with this year. There are a lot of people in this country who are very concerned that our election process has been thwarted to the point that they don't trust that anything else that happens is actually valid anymore. And having been a poll watcher, I have so many people who come to me and ask me about it and whether or not I saw compromises in integrity and law. And the fact is I did. And so I'm very concerned about this, and I hope that I love what you're trying to do here. This is just part of many things that need to be cleaned up. Texas has some good laws, I understand, but unfortunately, they're not always being followed. And so my experience, what I want to speak to first is that I want to suggest that language is added to include recounts to this, because recounts, early voting, and election day voting all deal with the same issue. And so I think that's really important. And then secondly, I want to suggest that there be, if possible, language added to this that emphasize the need for election supervisors to communicate and involve poll watchers. The idea is that we need to trust that our elections are honest, but that only happens when we can verify. And so for the sake of integrity in the state and confidence of the voters, we need to avoid the possibility that election supervisors, for the sake of convenience, are trying to do preparations on the side and beforehand, and then chain of custody is lost. So I'm going to tell you briefly what happened to me in July or August watching the recount. When the Bexar County people, in preparation for the recount, I suppose thought that they were helping things move more smoothly by opening the ballot boxes and bringing the ballots into another room in little boxes where they were no longer sealed. No one was there to watch them break the seals. And then those ballots were brought out to be run through the tabulation machines. But no one was there protecting them or watching them or confirming that no one had tampered with them. And so this section here under, on the first page, section 1A, that talks about the preliminary arrangements, I agree with the doctor here about preparing the process and keeping the language the same for clarity. But the poll watchers need to be there to see that. The same thing happened with early voting in Bexar County. I suppose they thought it was more convenient. There's this thing called a zero tape, and I don't know if y'all know what that is, but it means that the tabulating machines all have to be proven that every candidate there starts with 0 votes at the beginning of polling. And that tape is run, and it's supposed to be run that day as part of the preliminary process. But that was run down at Bexar County headquarters several days before. So we poll watchers never got to see that those tabulation machines started at 0. And so I just really want to encourage that the poll watchers be part of that whole process, if there's a way to include that.
Thank you, ma'am. I believe there are bills on that exact subject. There's
Okay,
bills
I'll be back.
on another one.
Thank you.
Yes. Thank you, ma'am. The chair calls Ed Johnson. You don't have to. Okay. I'm going to have to go through everybody, but You don't have to if I call your name, if you've heard people say the same thing.
Ed Johnson, here representing myself. I'm for the bill. I will tell you, start with defending Harris County. You should think of this on a voter-wide, not county-wide, because like 8 of the counties in Texas are 75% of the voters. So you're talking about voters here. And when you're talking about this, I had in county clerk's office, I had occasions where I was asked to go to polling locations because there were elected officials sitting at the check-in counter not willing to leave when the judge asked them to. And when the constable showed up, it was very confusing in the code because it's all over the frigging place to point out that that elected official is not an election officer and cannot be there, even though their name was on the ballot too. So codifying this would help a whole lot. And one last example, my wife was election judge this last election. She had to hire 8 workers. 4 of those 8 workers were provided by the county clerk's office.
Thank you. Members, any questions for this witness? No? Thank you, Mr. Johnson. This time, the chair calls Mr. Alan Vera. Mr. Vera, if you could please state your name, tell us with whom you represent and your position on the bill.
Alan Vera, Chairman, Harris County Republican Party Ballot Security Committee, testifying in support of HB 1128. It's almost embarrassing to admit that this bill is necessary, but it is. It's very necessary. For whatever reason, in the last 3 cycles, in several counties with more cars than horses, county election authorities seem intent on inventing new election positions that aren't in the code. In the last cycle, we saw deputy county clerk specialist with authority to overrule the presiding judge appointed by the county commissioners. Something's wrong there. We had a title called iPad specialist, whose only qualification was you be a teenager in high school with acne. And then we had the district attorney's election integrity task force, who showed up at polls not in response to requests for help, but to inspect, to conduct inspections not allowed in code. It's getting out of hand. It's getting out of hand in places where there are many more voters than horses. I think this bill's needed. It can use some massaging, certainly. And for sure, I want to echo the testimony of others before me on alternate judges. There's many bills moving right now that are going to elevate the importance and recognition of the alternate judges. They should be included. The only caution I'd have about the current language is this phrase, which appears frequently. A person whose presence has been authorized by the presiding judge in accordance with this code. Please make that specific, because we know a lot of presiding judges who will authorize catering, and we want to make sure that doesn't happen. This bill's needed. However you massage it, we've got to put the halt on some of these things that are being created at the local level that have nothing to do with the code, that in fact get in the way of the election code. Thank you.
Mr. Bear, thank you for that. Thank you, Mr. Chairman. Mr. Bear, thank you for your testimony. I have to make the observation of a famous Republican that there's nothing better for the inside of a man than the outside of a horse. And with that in mind, perhaps the problems in Harris County need to be dealt with in Harris County. We have these things every 2 years called elections. And if there's a problem with how people are acting in these elected positions, then perhaps, just a thought, find good people, support them, raise money, and change out the people with whom you have a problem. But to fix a localized problem by imposing a statewide mandate of things which are not needed in the vast majority of the, I think, of the population and also the geography of Texas is really unwarranted. I'm not unsympathetic to the plight that I've heard from some of my colleagues, but again, let's don't throw out the election baby with the Harris County water.
Yes, sir. 2 points.
It can be muddy from time to time.
2 points. Number one is understand that what starts in Harris County leaks out elsewhere, as Fort Bend County can now testify to. Okay. Secondly, we don't have local election code. We only have a statewide election code. If you want to turn it loose to have election codes for each county, we'll have a real problem. But the only place to solve these problems is with the state code.
Yes, thank you.
And I don't think, if Mr. Farrell would respectfully say this doesn't leak out with, I'm not saying there's a myopia of Harris County or its importance relative to the state of Texas, but it is kind of downhill in the third immutable law of plumbing, as we know what flows downhill, and it's not coming our direction. This is just, this is not a problem that is shared around the state. And again, I'm sympathetic, and we can look at some solutions, but let's don't make wholesale changes to the state of Texas with a system that works extraordinarily well. I'm one of the people that thinks Texas has one of the best election systems in the union. That we have remarkable elections. One of the things I think that works the very best is how quickly and efficiently they work, and that's in large part because of the people who run the elections, and that would be the election administrators and the clerks of this state. I am deeply concerned, and one of the witnesses said it a moment ago, that the erosion of confidence of the American people in the elective process is a critical weakness in our whole fabric of our society. The one thing I think that erodes it more than anything is not so much the incidents that happen in the elections, it's the delay in getting results of the election. And Texas stands heads and shoulders above nearly every other state in the union. And we're not waiting for days or weeks to find out who won. We're an impatient people. When we watch a game, we want to know the final score when the clock goes to zero. We do that in Texas, and we do that because of the effectiveness and the work that our election administrators, our clerks do, and the volunteers, and the election judges, and the poll watchers, all of us working together. So let's don't be hyper-focused on some of the problems. Let's pay more attention to the beams in our eyes and less in straining the gnats. I'll confess I'm a glass half full to overflowing guy. But again, I don't want to minimize your sincerity or concerns, but we've always got to be careful that we don't overreact to a situation rather than just addressing and doing some things that are reasonable and based on the evidence. But thank you, Mr. Bear, for being here.
And I would say that Representative Jeton's bill is very reasonable. Thank you.
Wonderful. Not so fast. Don't run off. Representative Schofield has a few questions for you,
Let
Mr.
me
Bear.
bring this back to Mr. Jeton's bill, if I could. Again, this bill doesn't aim at election administrators. We have a current statute, right? Chapter 61.001 that says nobody who's not authorized by the code to be here can be here.
Correct.
Mr. Jeton then files a bill that goes and gathers all those folks and says, here's who they are. Make it a lot easier for the election judge to see his list of who's supposed to be there and who's not. Correct?
Correct.
You're telling me that you've seen folks trying to do our job and create new legislation and create new positions that they want to let into the code. We have decided as a legislature who's allowed in, right? Whose job is it to rewrite the election code? Is it a local official? Is it the local county clerk? Or is it the Texas legislature?
It's the legislature.
So the current law and what we've got as our expression of law, if we do nothing else, is that none of these folks are allowed in. We have a bill from Mr. Jeton that says these are the folks who the code does allow in. Am I missing something? We're having this big debate about a bunch of things that aren't in the bill, right?
Correct.
So again, there's no attack on election administrators or clerks or tax assessor collectors or anybody else. This is just saying we're having a lot of people in the polling places who don't belong there. That allows for potential voter intimidation. It allows for potential cheating. It allows for a lot of things that shouldn't happen because those people have no business being there.
Mm-hmm.
Let's see who does have a business being here. Mr. Jeton has been kind enough to find out for us and put it in the bill. Is there anything else in this bill involving who can be in the polls on election day that I'm missing?
I don't think you've missed anything.
Thank you.
Thank you, Mr. Vera.
Thank you.
Members, at this time, I call Mr. Chris Davis. Mr. Davis, of course, if you could again please state your name, tell us who you're with, and your position on the bill.
Yes, sir. Chris Davis on behalf of the Texas Association of Elections Administrators testifying on the bill. I hope with my testimony I can help illuminate some of the concerns that the election administrators have and some of the concerns or where we're coming from in answer to Representative Schofield's question. My colleagues and I in TAEA wanted to be for this bill.
That's because we support HB 1128's attempt to clearly enumerate those persons that may be lawfully present at a polling place on Election Day. Echoing some of the other members' concerns, we initially contacted the author's office on the omission of county election officers from the list and were assured that it was an unintentional oversight, only to be told in a later callback that the explicit exclusion from the enumerated list was indeed intentional, was a response to limited incidents in a couple of counties, and that other parts of the code didn't support our unfettered access and presence during Election Day. As county election officers, we fully support and embrace Section 32.075, in which, quote, a presiding judge has the power of a district judge to enforce order and preserve the peace. But please note that we as CEOs, county elections officers, are part and parcel of that order. After all, we train the presiding judges in establishing and maintaining it. And as it relates to accessing to a polling place on Election Day, we come in peace, order and peace. It's not appropriate for a county election officer or their staff to establish some kind of aggressive adversarial capacity at an Election Day polling place. It's not. And if that happened, that's dysfunctional and inappropriate. However, it's entirely appropriate and supported by the election code, an established procedure, and in established procedure and in Texas Secretary of State training and advice for county election officers to have unfettered access to the Election Day polling place in a supportive and assisting capacity. Because contractually and most of the time, we are the custodians of the election records. We're the suppliers before Election Day and the resuppliers during Election Day of those Election Day polling places. In emergency situations, as was earlier pointed out, such as the early days of the pandemic, we're the on-the-job trainers of those emergency appointed, injected presiding judges. We have to do that at the polling place. In most elections, we're the employer of the presiding judge. Why then does HB 1128 as currently written not allow us lawful and unfettered access to those polling places and elections that we are administering? Is it truly the intent of HB 1128 to provide presiding judge, mother or father, may I, access to these sites when we at least have as much right and, more importantly, purpose to be there as that of a state inspector or federal inspector, whatever that is, or even a county chair? That's what I have.
Thank you, Mr. Chairman. Mr. Davis, can you, so we can work on this bill, can you spell out exactly what titles, what positions you think should be added to this list?
County election officers. Yes, other sections of the code may reference, and they do reference, sections where county election officers are present. But other sections of the code also mention watchers and county chairs and presiding judges and clerks. Why aren't county election officers simply enumerated in the list in this bill? Why must we seek permission from presiding judges that may not want us there, as Mr. Maxey pointed out, in instances where we have the authority from the party's county chair to issue an oral warning or remove them? We don't understand that as election officers. But to answer your question, county election officers and staff.
That's how you would phrase it?
Yes, sir.
Election officers.
And if it's in the capacity of their duties of all those, distributing supplies, training, appointing in an emergency capacity, retrieving paper ballots. So many counties are going into the hybrid paper ballot system. These machines overflow, and we may want to bring back those full ballots so they have, in order to maintain ballot security, so they have a brand new ballot bin in these tabulation scanners. It's all part of our process. Counties employ field technicians on a temporary basis. We don't want to employ staff and deploy staff that are aggressively adversarial at the polling place. But hypothetically, even if they were, does that truly usurp the district judge powers of a presiding judge, the presence of staff attorneys of Harris County?
Davis, I really feel like you're neutral on this bill right now.
Thank you, sir.
I'm glad you were to testify on it.
Well, But I will say it.
Walking that razor edge, Chairman.
So we can improve the bill and work together. Thank you.
Thank you, Mr. Busey.
The chair recognizes Representative Clardy to ask you a question.
There will be a question in here somewhere.
Okay.
Thank you, Mr. Chairman. And Mr. Davis, so I understand you correctly, what you would ask is that on line 17 of the current draft, inserted as number 1 should be county election officers and staff. Is that just a...
Mr. Clardy, we'd take number 11.
Take number 11?
Yes, sir.
I'd prefer number 1. That's no argument.
Representative Clardy, forgive me, sir.
But the one thing that I think Mr. Schofield said a moment ago, there's other provisions of the code. Aren't there other provisions of the election code that outline and describe impermissible conduct in the polling locations?
Indeed, there is. Yes, sir.
And those laws do not specifically exclude the EAs or the clerks or their staffs, the county election officers and or staffs.
Not to my knowledge, no, sir.
So the point would be that to the extent there may be some improprieties of someone who should be acting in an official capacity but has gone well beyond that and may be violating those laws, they are subject to those same laws and restrictions as we sit here today.
Yes, sir.
And the one thing, it seems to me, this is like telling the teacher that they can't go in the classroom to talk to their students during a school day. The teacher's hired to teach students. The EAs, the clerks, their staffs are hired to run elections, but you're not going to allow them in the one place where the one thing they're supposed to have control over. They can't go into that room to oversee, to look, to make sure things are there. It could be as minor as making sure there's bottled water for the people working there, or it could be as significant as following up on a complaint that there's somebody trying to harass or intimidate a voter, correct?
Yes, sir. Collaborative in that sense.
And there have been situations in the history, not often, but sometimes, where there have been things that have gone fundamentally wrong with an election. Is that accurate?
Indeed.
Who is it that is held responsible for that when it occurs? Whose proverbial butt is on the line? If an election goes wrong, if there's a major snafu that voids or threatens the legitimacy of an election, who is that person that is going to be put up as the poster child, be pilloried in the public, and probably beaten in the next election? Who would that be?
In most cases, Representative Clardy, that's the county elections officer. There are bills being proposed by members of this committee that would penalize county election officers for activities occurring in the polling place. Yet, ironically, we don't have unfettered access to those very same places where activities could occur, where we'd be criminally or financially penalized.
Things that go wrong in election that you'll be held responsible for, but you're going to be precluded from being able to go in, witnesses yourself, taking corrective actions that preserves the integrity of our elections.
That's our understanding, yes, sir.
That's my understanding. Thank you.
Chairman?
Mr. Schofield, you're recognized.
Mr. Davis,
Yes,
my understanding is you'd like to see language in here including the EAs or the election officials and their staffs, which would be a blanket admission of all the staffs. You heard Mr. Vera's testimony that in at least some counties they were making up phony jobs to get people in there, including one, I forget what title he gave it, or he said the county gave it, where they were told they had the authority to go in and overrule the election judge. What language would you suggest that we add to the bill that would allow your legitimate people in, but not allow the election official to name supposed staff who's going in there for improper means? And what penalty would you suggest for an election administrator who uses this loophole to get somebody in here to overrule election judges, intimidate voters, or do anything else they ought not to be doing?
If I understand your scenario, sir, and I believe it happened.
And it wasn't my scenario, was it?
And I believe it happened, yes, sir. Presiding judges were told that these appointees had authority that usurped the authority of the district judge. I'm no attorney, sir. I see that nowhere in the code where a district judge's authority can be usurped by iPad technicians or deputy county clerks, regardless of what is said.
And who were they told that by?
County. They were told that by the county. I stand advised, sir. Yes, sir.
That was my understanding. That was the allegation.
But the code, as I read it as a layman, sir, has no provisions for that whatsoever. I'd love to hear what the resource witnesses of the Texas Secretary of State have to say about that.
Well, that's my concern. That's why I asked you the question. Current law doesn't, it was illegal. Current law does not allow them in there for that purpose. If we give you a blanket authority for all you guys who are doing it right, and we say them or their staff, they're now blessed and would be legally present where today they are not. Why would we allow that?
Representative Schofield, can we start then with just the county elections officer?
Absolutely.
That would be nice, sir. If we could be enumerated on that list, given that it referenced us and the code as it exists today implies that we're the authority responsible for procuring election supplies. And we're the authority for removing a judge with the approval of a county chair following an oral warning.
Now, let me ask you this. If Mr. Jatan made that change and said the election, what was the word?
County election officers, I think it covers both EAs and county clerks.
Themselves. So, yeah, or just putting all three of those titles in. If they were added to the list of people who are allowed in the polling place, would you be for the bill?
It would greatly allay our concerns, and yes, I think our association would be for that bill.
Thank you.
Thank you, sir.
Thank you, Mr. Davis. I assume there are no other members who want to ask you any questions. Thank you. You can be seated. That'd be wonderful.
Thank you, Mr. Chairman. On my way.
At this time, the chair calls the great Keith Ingram, Director of Elections Division, Texas Secretary of State. The beard is longer. Goes with your wisdom, Mr. Ingram. Mr. Ingram, you know the drill. If you could give us your name, who you're with, and your position.
My name is Keith Ingram. I'm the Director of the Elections Division at the Texas Secretary of State's office, and I'm here on House Bill 1128. One thing before we get started, I need to make a confession. Our presiding judge handbook has an error in it that we have discovered through the testimony today. Currently, our presiding judge handbook says that a person allowed in the polling place is federal observers. That is incorrect. Since June of 13, when pre-clearance went away, federal monitors do not have any business in Texas polling places. So,
thank you. I can only imagine maybe it was somebody from the Senate that wrote that. It's wrong. So, thank you, sir.
We're going to correct that mistake in our handbook. I don't know if we want to leave federal inspectors on this list, but if we do, we should probably define them more carefully to say monitors from the DOJ instead of just anybody from the feds.
Wonderful.
Okay, sorry.
You wanted me to open it up for questions? You got something to tell us?
That's it.
Members, are there any questions? Representative Swanson, go ahead.
Yes, thank you, Mr. Chairman. And hello, Mr. Ingram.
Howdy.
I am greatly supportive of this bill. I think we do need to clarify who can be in there and not be in there. I want to clarify, what do we do? As somebody who has held many elections for decades and also observed others as having, been outside electioneering, I am concerned about all the incidental people who need to come through. That are we now making them criminals? Okay, I would list, so we first started out with, the husband or the janitor or whatever who set up the tables and drug around the chairs, and during the middle of the day you go, hey, we need another table. Can you bring us some, we need more chairs. That comes up frequently. We got to have people be able to come in, leave that stuff, and go out. You have the man who comes into, or woman who comes in to fix the AC because it's not working. You get a leak in the pipes, you got to have a plumber or somebody come real fast. People who, the coach has got to cut through the gym where you're holding your election because that person can't get to their office otherwise. Many elections I've seen in a giant foyer of a church, and hey, the church members cut through, and the employees. Doesn't mean they're hanging around. The election judge is making sure that they are not hanging around. I would also include people who are electioneering who put on their jacket and cover up their shirt, leave their literature outside, but they've desperately got to go to the restroom. Can you just tell us how we would deal with that in the current law, and how would this bill affect that?
So all of those situations are covered by current law. You know, and this bill allows technicians, so I think that covers some of those categories. But the law right now allows people who have business in the building to access the building, but they can't hang out at the polling place. So if they have to access the building because they've got business there, then and I would assume that using the restroom is included in that category. So current law allows that. This bill doesn't affect that. And from what I was hearing when you were talking earlier, I was understanding you to be setting up the polling place the day before the election.
Typically, yes, and just wondered about that. Is it important to swear that person in? What if they're underage?
No, because this 61001 only comes in when it's a polling place. So
Okay.
before it's a polling place, it's just a room. And anybody
Okay.
can be in that room.
Okay, thank you.
Members, I really expect you to have great questions right now. Who would like to be recognized first? Really? Okay, I mean...
Can I say one more thing voluntarily then?
Yeah.
Right now we have a provision in the code that lets party chairs on election day perform administrative duties in the polling place, and we could transfer that language for county clerks and election administrators to be in the polling place to do administrative duties. That language is already in the code.
So,
Thank you. The chair recognizes Representative Jeton.
Mr. Ingram, question about county clerks and election administrators. Because there were conversations and discussions about their role in the polling locations, ballot board areas, and so forth, prior to laying it out today. And the conversations that I had was there wasn't anything specific in the code that said what authority they had in those locations, other than as a technician or to drop off supplies. Is there anywhere else in the code currently where they have that authority?
There is not, and that's what today has revealed to me, that we have a basic misunderstanding about their role in elections. I agree that Clerk Hawthorne is the boss of the county clerk's office, and she's definitely in charge of the election. But in the polling place on election day, she is not the boss. The election judge is.
So to follow up on that, do you believe HB 1128 changes their authority in any way?
It does not. But if we wanted to clarify it, we could give them the same authority that we currently give party chairs, which is to perform administrative functions.
It would be a totally different bill, I think. Thank you.
Thank you. Yes, just repeat. Right now, we're not at. Are we? What kind of changes do you feel like we're making to the existing code? Are we making anything new, or are we clarifying things?
The new thing would be allowing federal observers in. That's new. And then the other new thing is, it might not be, depending on what you think of the discretion of a presiding judge now, but that bit about allowing them to have persons come in accordance with the code, I don't know that currently exists.
Yeah.
Outside of their discretion as a...
So we're actually going further. We're not undoing something that wasn't already there.
That's correct.
Okay. Thank you, sir. Members, any other questions? Okay. Representative Swanson, you're recognized.
yes, just to clarify slightly more for totally innocent people, having been in this situation many times. Okay, what if the extra people who are setting up, the janitors or the husband, whatever, is there that morning? Is it important to not open any election? Like, does all the arranging need to be done and then you kick that person out before you actually do anything election related? And at the end, if there are people, janitors or other people just coming in for manual labor, is it important that they cannot come in till every box is sealed? Just if you could clarify both those questions.
I would agree with both of those. You know, it depends on when it becomes a polling place. And whenever you start opening the machines and running the tapes, I think that's when it's becoming a polling place, and outsiders don't need to be there.
Okay. And the same at the end of the day?
Yes, ma'am.
Okay, thank you.
The chair recognizes Representative Schofield.
I just have one. I keep trying to bring this back to the bill. This bill, as you read it, doesn't bar anybody who currently has a legal right to access the polling place to access the polling place. Is that correct?
Completely agree with that.
Whether it's EAs or whether it's your parties or your friends that want to help you set up, this law just clarifies a list of who's allowed to be there to make it easier for the judge to know who they can eject for loitering.
I agree with that. The one difference is
Other than
with
the federal.
regard to the central counting station. I agree with the previous testimony. You know, the watchers are allowed to be at the central counting station when it is convened, not just when ballots are counted. So that when ballots are being counted, it's more restrictive than what current law is.
Okay. But as far as the poll, because all of our testimony's been on the polling place on election, I think anybody talked about the central counting station. But we're not, if we pass this bill, we are not excluding people who have a current right to be in the polling place. It sounded all morning like that's what we were doing. We're codifying all the different folks who are currently allowed in.
I agree with that.
Thank you, sir.
Thank you, Mr. Ingram. Any other questions? Thank you. Is there any other person who wishes to testify on, for, or against this bill? Okay. Representative Jeton, you may now take your place back on the podium, where first-time bill layout members must all go. It is, you're recognized to close, sir.
Thank you, Chair. So glad this is my first bill. This has been an exciting one, and I take full responsibility for the confusion with all this. I think it would be important to, again, clarify that this is a very specific part of the statute. Doesn't change the authority anybody has to enter those locations. The idea was to codify it in one place so that elections administrators and election workers were able to better enforce order in their polling locations, ballot board areas, and the calculating areas. I believe the need for consistent and clear guidelines for elections in our state from the state legislature is absolutely necessary to ensure public trust and accuracy in our election. And so if there's no further questions, I will close.
Thank you, Mr. John. Mr. John, Representative Clardy does have a question for you.
Good.
No, not a question. I just want to congratulate you, Representative John, on your successful first bill layout. And I'd also want to say I look forward to you having your first bill on the floor.
Thank you. I look forward to that as well.
Thank you, Mr. John. Forgive me, y'all, we're having some discussions back here for a moment. If the clerk would please, play the hold music or anything like that. By the way, I want to acknowledge that Mr. Williamson's wife did a great job dressing him again. So he's got, did the socks match? Yeah. Please rise. Right.
part where I sing. Not as part of the hearing, but just generally. Lots of our Good. So, you know, I've never seen that to me would seem to be. Yeah, I don't think you're supposed to do that. I doubt very much. They're not supposed to, under current law, no, they're not allowed. 61 Earl 2 doesn't allow it. And part of the reason what's the bill is because the buildings right now they don't have it.
Yeah. Art, get him. Get off the phone. So I just say the chair moves. What's all this bullshit?
Yeah, the chair,
Chair
that's what
moves,
you
yeah.
call someone else. So just the chair moves the decimal level. So if it doesn't pass,
Yeah.
then here, it's not unanimous. This one,
course.
yeah, okay. So required.
Yeah. Just say required vote. All right, if the raucous crowd could begin to
Raucous.
get back to their seat.
Okay, we're good.
Thank you, members. We're going to move on to some voting. We still have before us House Bill 1128 by Representative Jeton. At this time, the chair moves that House Bill 1128, without amendment, be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane,
Aye.
Vice Chair Gonzalez, Representative Beckley, Busey, Clardy,
Baseball conversations. Aye.
Fierro,
Aye.
Jeton,
Aye.
Schofield,
Aye.
Swanson.
Aye.
There being 8 ayes and 1 nay, the motion passes. All right, members, you may recall House Bill 478. I'm going to proceed with that. The chair moves that House Bill 478 by Gonzalez, without amendment, be reported favorably to the full House with a recommendation that it do pass and be printed. The clerk will call the roll.
Chair Kane,
Aye.
Vice Chair Gonzalez, Beckley, Busey, Clardy, Fierro, Jeton,
Aye.
Schofield,
Aye.
Representative Swanson.
The motion passes. 9 ayes, 0 nays. Prevails. Now you may recall a similar bill, members, House Bill 22 by Representative Swanson. We're going to go to a vote. At this time, the chair moves that House Bill 22 by Representative Swanson, without amendment, be reported favorably to the full House with a recommendation that it do pass and be printed. This time the clerk will call the roll.
Chair Kane,
Aye.
Vice Chair Gonzalez, Beckley, Busey, Clardy, Fierro, Jeton, Schofield,
Aye.
Swanson.
There being 9 ayes and 0 nays, the motion prevails. Yep. Thank you. Members, this concludes today's agenda. Is there any further business for the committee to address? If not, the chair moves to adjourn. Is there objection? Hearing none. The House Committee on Elections stands adjourned, subject to the call of the chair.